Hi, Erin. If you're here, can you please turn on your video and let us know?
Hi, good afternoon, everyone. We had a very lengthy first part of the day. We'll see what we can do here. Obligated to really make some opening remarks, so I'm going to go through these as quickly as we can, but here we are. So we're meeting Committee of Adjustment, which is authorized under Section 45 and 53 of the Planning Act, and the committee does a number of things. We've got a jurisdiction to give variances from the provisions of the zoning that applies to property. We also give permission to extend or alter lawful non-conforming uses, and we give consent to sever property to create new lots. Before we go further today, we want to acknowledge that the land we're meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and it's now home to many diverse nations, Inuit and Métis people. I want to specifically acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. All right, just in terms of our conduct here and our proceedings, so Committee of Adjustment hearings are now conducted in a hybrid in-person and virtual format. I think everyone's getting more used to that. So some applicants may make their submissions in person, and others will participate virtually by electronic means through WebEx, an online digital platform. Meetings are also streamed on Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch you on YouTube. Those who want to participate virtually and have registered in advance, they'll be connecting through their computer or tablet or smartphone, and they have the option of participating via video or audio only. All virtual participants will automatically be muted on entry. When your item is called, you will be unmuted by the moderator, one person at a time, and we ask that you also mute your devices until you're called on to speak. Those persons participating by video appearance, they'll be temporarily upgraded to a panelist when your item is being held. During this time, your camera will be enabled when your item is on. You'll only be visible during your 5-minute allotted speaking time. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Those participating through WebEx are not allowed to use share screen or any other panelist control during a video appearance. If you do that, then you will be stopped. Copies of the decisions from committee today. People attending in person today who also want to receive a copy of the decision of committee on an application must fill out a decision request card. And those participating virtually need to submit a written request for a decision by email. Please ensure that you include your name, address, and email address, because the Committee of Adjustment and the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you don't agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body, or in some limited circumstances, to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons, and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the committee. And instructions concerning appeals will be set out at the bottom of the decision. Okay. We're going to call the items in their order on agenda this afternoon. Where an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for a decision. Each speaker, including the applicant agent, will be given a maximum of 5 minutes to address the committee. I'll comment when you're reaching that 5-minute limit, and you'll be asked to sum up then. Okay. In terms of materials, anything that you had wanted to submit to committee must have been emailed in advance of the hearing. Staff and committee cannot accept materials at the hearing. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matters outlined in the application. The application or agent will proceed first and will make a presentation to the committee on the application. Please note that the committee may not entertain revisions to proposals at the hearing today. The committee may decide to defer the application if substantially revised to ensure the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then we go to individuals, either in support or opposed. They'll be invited to speak. Generally, we first call on speakers who are here in the hearing room, and then those participating through WebEx. Committee members may ask questions of each speaker after they finish their presentation. When all speakers are finished, the applicant agent has an opportunity to rebut only those issues that were raised by the speakers. That'll mark the end of the discussion, and the application will then be taken into committee for a decision. Madam Secretary Treasurer, we dealt with minutes this morning. At least there's nothing to adopt at this point.
Through the chair, that's correct. No minutes for this afternoon.
All right. And members, is there any declaration of interest or conflict for items for the afternoon's agenda?
Through you, Mr. Chair, I have a conflict with item number 23 for 227 Gerrard Street East, and the reason is I've had quite a bit of involvement with this application, and I am also a member of the Cabbage Down South Residents Association, which I see has submitted their own correspondence.
On that. All right. All right. Thank you for that. We'll note that.
Through you, Mr. Chair, I also note that Mr. Cheng, Member Cheng, had declared an interest for item 34, and that he will not be present during that item. And presently, right now, Mr. Cheng is not with us at the moment, but he will be returning later.
But he won't be participating on 34, 93 Mackay Ave.
No, he will not.
Okay. All right. Thank you very much. That's helpful. Okay. And yes, I think that's, I take it, Madam Chair, there are no further requests for deferral.
Through you, Mr. Chair, there is one deferral request for this afternoon.
Okay.
That is item number 19, municipal address 171 Pendrith Street /23 TEY.
All right, do we have the applicant agent on the line for this? I think we should proceed with the deferral.
Through the chair, it depends if we have a speaker. Staff, do we have speakers registered for this item?
Through you, Mr. Chair, there are 2 registered speakers, but I'm still trying to locate them.
Okay, through you, Mr. Chair, we
Yep.
don't have the registered speakers on the line at this time,
Okay.
so we should proceed in order, I recommend.
All right then, so we start with 18A, B, and C, and I'll just mention for those that are here. So we have a consent application, so really a dividing of lots, and we have 2 associated minor variance applications. So we have a severance and minor variance applications, and this is for 3234 Fernwood Park Avenue. And from the staff material, then I'm just going to read what's requested, etc. So for this address on Fernwood Park Ave, there's a request to obtain consent to sever the property into 2 undersized residential lots and to create an easement or right-of-way. The purpose of the application is to maintain the existing 2-story semi-detached dwelling. This dwelling will be unaltered. Then also, yes, and to maintain the existing 2-story semi-detached dwelling, yeah, this dwelling will be unaltered. So committees had before it in connection with this a draft plan of survey, a copy of plan of survey, site plan, floor plans, and elevations, 2 photographs of the subject property, covering letter from Matthew Rutledge, agent, and we have a correspondence from a community planner, There are staff reports from Development Engineering and also from Urban Forestry. Those persons showing as an interest is correspondence and concern and from Daniel Wang, who's with 30 Fernwood Park Avenue. And I believe that's it, yes, for material before us. So could we have the agent then online? I presume that's Daniel Wang.
Through you, Mr. Chair, the agent is Matthew Rutledge, and
Oh, okay.
Daniel Wang is the registered speaker in interest.
Thank you. Okay, Matthew Rutledge, great. Hi, Mr. Rutledge, you're online? See if he's there.
Hello?
Hi there. Is this Matthew?
Yes, this is Matthew Rutledge. Can everyone hear me?
Yeah, I think pretty clearly. Thank you. All right, you have 5 minutes, and we were just advising everyone that, of course, there's a consent to sever here, and then presumably minor variance applications to dovetail with that.
Thank you. So I guess I would just ask if it would be possible to pull up the survey as well while I begin my discussion.
Okay, all right, we'll do that. And,
Thank you. So members of the committee, my name is Matthew Rutledge, and I am the lawyer for Irene Bauer, who is the trustee for the estate of Clara Bauer, which is the registered owner of the property, which is municipally known as both 32 and 34 Fernwood Park in Toronto. So the proposed applications before you today are a consent application and 2 minor variances to facilitate that consent. And what is proposed is essentially to simply sever off 34 Fernwood Park from 32 Fernwood Park. And the proposed areas for the right-of-way is to facilitate access to the rear of 34 Fernwood Park over the rear of 32 Fernwood Park, so that there can continue to be parking at the rear of the lot. So if you are to actually just quickly go to the draft plan, the proposed severed lot there is part 6 or 34 Fernwood. And the proposed retained lot would consist of parts 2, part 3, part 4, and part 5, which would be 32 Fernwood. Parts 2 and part 4 are the areas which would be subject to the right-of-way. And there is already an existing right-of-way over part 1, which is in favor of the currently full existing lot, which provides essentially with a reciprocal right-of-way over part 2 to provide for a mutual driveway along parts 1 and 2. So the total area of the proposed right-of-way, which would facilitate there to be access to 34 Fernwood Avenue Park, would be over parts 2 and part 4 with a total of 22.4 square meters. A summary of the variances which are sought is found at the covering letter on page 2. So the property is zoned as R residential under the City of Toronto zoning bylaw 569/2013, which requires a minimum lot area of 180 square meters. The proposed severed lot, or the North Lot 34 Fernwood Park Avenue, will have an area of 168.4 square meters, and the proposed retained lot will have a total area of 161.5 square meters. Similarly, the required minimum lot frontage for both of the required properties is 6 meters, and the severed lot will have a frontage of 5.44 meters, and the retained lot will have a frontage of 5.26 meters. And then the last variance which is being sought is with respect to the FSI. So the zoning requirement is for 0.6, whereas the proposed FSI for the severed lot will be 1.2, and the proposed FSI for the retained lot will be 1.3. So just for some background context here, the currently existing building is a 2-story brick building that consists as a 4-plex, and there's 2 dwelling units located at each side. So there's 2 dwelling units at the 32 Fernwood portion, and there's 2 units at the 34 Fernwood portion. And they effectively operate already at 2 separate properties. And in fact, there are actually 2 separate parcel registers for each half of these lots that are proposed. Under the City of Toronto official plan, the property is designated as neighborhoods and is not subject to any site-specific policies or secondary plans. And the applicable policies of the official plan generally speak to what, generally when you look at them collectively, is to ensure that the type of built form maintains consistency of the types of buildings within neighborhood areas, ensures that development re-inspects and reinforces the character of the neighborhood. And a list of those policies which would be applicable are found at pages 3 and 4 of the covering letter. So this application is really quite straightforward, as there is no development that is proposed, no construction. It is simply to continue to maintain what already exists, but it would allow each half of the existing building to be conveyed as separate parcels. So again, if you go back to the draft reference plan, it splits it right down the middle, and that aligns with the property line, actually aligns with the shared party wall that goes down the middle of the house. So since there is no change or proposed development, the lots will continue to enforce and maintain the existing physical character of the neighborhood by the proposed lot sizes and configuration being consistent with other lots in the neighborhood, and the proposed duplexes consisting of an existing building that has the same size, height, and massing, scale, and density of the other types of dwellings found, you know, immediately to the north and to the south, across the street, and all through the neighborhood.
Excuse me, Matthew, all right, we're over the 5-minute limit, so I think we're going to have to leave it there. Thank you for those submissions.
I apologize, I couldn't see the timer.
All right, so we have, I'm sorry, are there questions, comments?
Do we have any speakers? Okay, I'll ask my question after.
I'm sorry?
I'll ask the question after the speakers.
Oh, sorry, all right. Fine, well, we just have Mr. Rutledge as the speaker, sorry.
Daniel, you've been unmuted.
So we'll hear from the interested party, Daniel Wang. I could use some technical assistance here, just with respect to the large monitor. I just wanted to get my documents, the documents to open there, and I've been able to migrate to that, but. Okay, thank you. So we're at 18, we're at 18, all right. And can I tried to move that over there. Perfect, that's going to assist, thank you. All right, we're checking to see if Daniel Wang is available.
I'm here. I hope you can hear me. I'm actually connecting you from abroad in Dominican Republic. I apologize if the internet is spotty here.
I take it you knew it was snowing here this morning.
Oh, that part I'm glad. Okay, I didn't know that.
All right, yes. All right, so we've
Great.
had a presentation from the agent with respect to this severance and to the minor variances that are sought. Would you please go ahead with your submission?
Yes, I would like to. My name is Daniel Wong. I'm at, I own and my principal residence is at 30 Fernwood Park. I'm the gentleman who actually owns the driveway, which is the right-of-way that's been provided, as well as a portion of my rear lot, which is right-of-way. First of all, I'd like to mention is that I just don't understand why I have not been communicated directly about such an important, there's a potential impact, because I'm the owner of the driveway in question that they're trying to sever the property, which also transfer a right-of-way for the, for basically it's a deeded right for the egress and ingress of vehicles. So I'm just curious why I was not approached directly. I mean, it would have been a lot better neighborly. The other thing is that I like to mention I do have history with Irene Bauer. Irene Bauer had actually ironically objected to my Committee of Adjustments approval, well, before the approval, for the same issues that I'm actually bringing up as a concern, but not objecting. They'd like to be open to her proposal versus objecting to my proposal, which were 3 existing parking spaces in the back. She was concerned that having the 3 existing parking spaces approved, it would impede and exacerbate her situation where she claims that she has 4 parking spaces in the back for her tenants, which is not true. Thank you for bringing up the document. The pictures will actually be very helpful. So I would like to bring up, my main concerns are really with parking. The other thing is the impact on housing, but the main thing is that having, right now, because of a fence where the southerly neighbor, the other side there's a partial fence, I'm no longer able to really use 3 parking spaces that have been approved by the Committee of Adjustment back in June 24th, 2020. I can only use 2 because of a partial fence. So my first concern is that what if there's another fence being built? If this lot was severed, what prevents the new owner from putting up a fence similar to the one I have with my southern neighbor, who I take care of? And that in itself could be an issue. My other thing is that Irene Bauer had claimed that she needs all 4 parking spots for her tenants. As you can see, with the parking, she could only have 3 people parked there, and only 2 of the parking spaces are used by tenants. A third one's actually rented to a neighbor. One of the tenants, one of her tenants actually says she can't afford $100 a month for the rent, so she's paying $17 for street parking. And here I am, I can only use 2 out of my 3, and I have to pay $100, almost $100 a month to have my third vehicle on the street. So I have I felt there's a bit of unfairness there. So you can see that if they severed the lot, there's no way they could park the vehicles perpendicular to the length of the lot. For example, I believe it's called the conveyed lot, where the lot that gets severed. If it gets conveyed, there's no way they could actually park that way. If you could move the picture to the next picture, where if you could see if the property is severed, you see that red line there. All the vehicles will basically be jutting out into the I guess it's called a retained lot, number 32. So unless there's a way you could do that, I don't know. So can you still hear me? Just having some battery issues.
You're fading out a little bit.
Yeah, because of my batteries. So I'll just have to say is that my concern is what prevents the new owners of the property to add a fence, or what prevents the new owner saying, hey, I don't have parking here, number 32, so I'm going to put some soft landscaping, And then it would interfere with my existing parking, where I could barely park 2 vehicles. My neighbor to the south, 28, she has to go into 32 and too far to get out. So there's no way they can even park a car there, because that's being used to ingress in. So sure, that might be ending up with 1 parking spot if there's a partial fence built. So again, I didn't have time to figure out from a lawyer whether that deeded right-of-way vehicle egress is that transferable. So there's a severance. So can number 32 actually transfer the right-of-way access from my lot to number 34? I mean, you're dealing with a different title of a different property now. So I have some concerns about that, because I would love to be able to negotiate that, because right now, currently, for 32 and 34, they do no maintenance. I have to do the maintenance. I do the snow shoveling, the raking, they provide no salting. I shovel their area. I rake, because if I don't, the snow gets blown into my area.
Oh, hi.
And
Hi, sir. You're past your 5 minutes.
okay, that's fine. That's why I wanted to mention. I won't talk about the whole impact on housing, but thank you so much for letting me speak my concerns. And
Thank you.
thank you.
All right, I guess we'll go back to Mr. Rutledge. Then we see another speaker. Any question or any question? Yes. Hang on a moment, sir. Yeah.
Sorry, so I've got a question for you. The points you make, I understand the issues that you're raising, but I don't actually understand how the severance affects any of them. Like a fence could be put in these areas by the current lot owner. The access looks like it's going to be the exact same access for the same number of cars as are there today. Is there something I'm missing? Like I just
Yes.
want, yeah.
Yeah, so right now we're having difficulties even to move the cars out, in and out. These are compact and medium-sized vehicles. So I even have her tenant, for example, that black vehicle on her side, to even help drive that vehicle out.
Sorry, sir. That's not what I'm really getting at is, by severing this existing condition into two separate lots, how does that change? So I understand that you have a whole bunch of issues, neighborly issues having to do with this right of way, but how does the actual severance affect or change that? Do you have a sense of, is there something I'm missing for that?
Yeah, what I was trying to say is that they could build a fence just like my neighbor to the south.
Yes, but that's
partial
something they
fence
could do
that gets in
now
the way.
anyway.
Yeah, I can't. They could do, but I can't park. I can't park. I can only park 2 vehicles and not 3.
Oh, okay, thank you.
I've been. Yeah, thank you. Yes.
Members, any other questions? No, all right. Okay. All right, we can go back to Matthew Rutledge then, please.
Thank you. I'll just try to be brief here, but if you could quickly pull up the survey again, I just wanted to clarify a couple facts.
Thank you. Yeah.
So the southern part of the mutual asphalt driveway there, that is on the property that belongs to the neighbor at 30 Fernwood, where there's the small portion that is just located on the north side of the property line that is also comprises the mutual driveway. So, and the existing right of way allows for the current subject property, which is 32 and 34, to use that mutual driveway to provide for access to the rear. So just wanted to clarify the facts around that. That is how it that's the current situation. So the dominant, the beneficiary of that easement here is both 34 and 32. So they'd be able to continue to use that mutual driveway in the event there is the severance. As far as the neighbor's concerns with respect to potential impacts on parking, I would just like to note that there is no requirement under the bylaw for parking spaces to be provided for duplexes, and that in any event, parking on the street would be permitted if they chose to do that anyway. And as far as it goes to with respect of any kind of renegotiation for maintenance of the mutual driveway or there being a fence, it's just our position that those are neighbor matters and private matters that shouldn't be considered by the committee. Thank you.
Yes, there's a question for you, sir, from one of the members. Yes, Mr. Allison, go ahead.
Thank you, Mr. Chair. Just a clarifying question. So perhaps you could speak just briefly to the significance of Part 2. Is that part simply to widen or provide to sort of widen the right-of-way such that you don't require access over the neighbor's property? Or maybe you could shed just a little bit more light as to why there is a Part 2 there.
Yes, so just to get more into the legalese of it all, I guess with the mutual driveway, through instrument CT 812537, that is the instrument where it provides that there is a right-of-way for the benefit of 32 and 34 across Part 1. And then there is a reciprocal right provided over Part 2, but for 30. So those two parts collectively, those two sets of mutual exchange of rights creates for a mutual driveway. So while 32 and 34 already have a right over Part 1 for the mutual driveway, if there was to be a severance of Part 6 off, technically it wouldn't have been granted a right over Part 2 because Part 2 is only being for the southern property. So the creation of that right-of-way interest is just to facilitate over that small sliver Part 2, because technically right now that's only for the property to the south. And then Part 4 would be for Part 6 to benefit of.
if I understand correctly, then the occupants at number 34 are, the intention is to use the portion of the right-of-way that is on your client's side of the property line in addition to that sliver of Part 2 to facilitate the vehicle going through? Or are they relying on, maintaining the right-of-way over the neighbor's property in addition? It's just a widening?
Exactly. The issue, as I understand it, is that it's going to be the identical right-of-way to existing.
Yeah.
But what they're saying is the right-of-way that's currently on the existing property doesn't actually give a right-of-way to the new lot. It only gives a right-of-way to the neighbor who we were just hearing from.
Right.
So the idea is that both properties would use the entire right-of-way coming from both properties, both the southern property and the northern.
Okay.
If that makes sense.
Yeah, thank you.
So sorry to step in, but
No, it's helpful. Yeah, it's helpful. Thank you.
All right.
I
Go ahead.
do have a question for the applicant, which is why this, in some ways, this looks like it always should have been a duplex and it's already separately numbered. How did this condition come to be, that it's one property?
It's my understanding that it just always has been one property. We're actually not sure why there are two parcel registers for both. We've looked into the historical significance of that to see if this is just a technical severance, but we were unable to confirm if at one point they were two separate properties.
Okay, and what's the purpose or rationale for pursuing this now?
So the late CLAIR Bauer passed away, and this is part of the wrapping up of the estate, but there is a desire to convey the two, essentially, I'll call them duplexes, separately. But you should note that if you look immediately to the south, which with the neighbor's property, as well as for the properties to the north, the exact same situation exists where there are what really are fourplex buildings that end up being two separate duplex buildings, or a building that is split down the center through the property line. So this is a very common situation in this neighborhood. This isn't out of the ordinary at all.
And do you have any comment on the issue that was raised? So if these do get conveyed separately, now that as part of wrapping up the estate, this idea that for the northern lot number 34, they can't actually park cars sort of parallel to the rear wall of the house in that, wholly within that lot. Is that, do you have any, I think that was one of the issues raised by the neighbor. Do you have any comments on that?
My comments would just be that they may have to change the manner in which they park to fully fit within of course, the severed parcel. There appears to be space to do that, but in any event, no parking spaces are actually required for duplexes in residential neighborhoods, and it wouldn't be a requirement to satisfy the needs in order to facilitate the severance. If they wanted to park on street today, they could do so.
No, I understand that, but there is a lot in the severance about preserving these rights of way. So presumably the idea is that there will be parking. So
yeah, there should be at least enough space for at least one parking space, and then if the new owners were to want to have more additional spaces, or subject to confirmation of all the dimensions, then they could pursue a potential variance for additional spaces. But my understanding, and based on the dimensions as I've seen here and as part of what we've submitted, there is sufficient space to maintain parking spaces at both the retained and severed lot.
thanks.
Okay, I have one question that I'd like to make a motion. So one question to the applicant. So engineering construction services asked that the two properties be serviced separately with septic and sewer and water. Is that an issue?
No, there is no concern with the proposed condition.
Okay. So I'd like to move this application. I do find it minor in nature. I think that the solution to provide the means of access to the rear of number 34 seems to be an appropriate solution. And I move that we accept this motion with making notation of the engineering and construction services staff report recommendations.
Through the chair, there's also urban forestry conditions recommended.
Yes, there is.
Urban forestry number
2 and 3.
2 and number 3.
Yes.
And just for the record, we can have one motion for the consent and the minor variances, but please, let's just make it clear for the record that this motion is pertaining to the consent and both minor variance applications. And the conditions are separate for the consent versus the minor variance. So for the consent, there would be standard consent conditions,
Yes.
plus the conditions imposed or recommended by engineering services just pertaining to the consent. And then for the consent application only as well, the urban forestry conditions 2 and 3. The minor variance applications didn't have specific conditions.
Thank you.
Thank you.
So
Is there a second to
I'll
that?
second it.
I'm not going to restate that, yeah, that's pretty good.
All right, that has been seconded. All in favor then? All right. Yes, that passes. Passes both the severance and the variances.
Thank you.
Thank you.
Thank you. You're welcome. Madam Secretary Treasurer, just while we look to see if that person who wanted to defer, if that person is online, I just got my notes from this morning. I'm just looking for what I have for the afternoon. Seeing them. Paper. Not sure that has disappeared too. Okay, so just for a moment, going to that item 19 on Pendrith, do we have the person available who is seeking a deferral?
Addison, you've been unmuted.
Thank you, Mr. Chair. Yes, I am here. I'm the agent for 171 Pendrith Street on behalf of the owners. My name is Addison Milne Price, planner at Design Plan Services located at 900 The East Mall, Suite 300.
Thank you. We understand there's a request for a deferral, and we just wanted to hear the reason why, and then we can deal with the matter.
Absolutely. Thank you, Mr. Chair. So the reason that I'm requesting a deferral today is because the needs of the property owners have shifted in the past few weeks, and as such, the proposal that's currently in front of you will no longer meet their needs. To be more specific, a new member of their family has decided that they would need to move in with them. And as such, this proposal will not be able to accommodate them. I'll note, just for your information, Mr. Chair, that this application was originally deferred previously in the summer of 2023, July 26th to be exact. The reason for that deferral is different from this deferral. I just want to make that note. We originally deferred to address concerns that were brought up from the neighbors, and I'll note that the application before you now does only have 2 variances. We worked for quite some time to essentially try and remove every variance possible. Despite these efforts, the property owners have realized that the proposal does not meet their needs, and as such are requesting a deferral to revise the proposal.
So you revise it, say, as opposed to just closing our file on this.
Yes, sir, that is correct.
All right. Yes, okay. All right, I'll just get my materials. Yes, so thanks. Just asking you to hang on because we're just going to review what the purpose of the application was and go from there. So on 171 Pendrith, to alter the existing 2-story detached dwelling by constructing a complete 3rd-story addition, a 3-story rear addition, and a 2nd-story partial side west addition. Also to construct a rear ground floor concrete deck and stairs, a rear 3rd-story balcony, as well as a rear basement walkout. The existing ancillary building and attached garage in the rear yard will be maintained and unaltered. All right, sir, so I think we have a motion then to defer this application to a later meeting of Toronto.
Through the chair, sorry to interrupt.
Yeah,
So just
okay.
in terms of, for the record, for registered speakers, we did have 2 registered speakers, one in opposition, Robert at 88 Spadina Road. Upon multiple attempts by staff via email and phone call, they were unable to reach Robert. And then the second speaker we had registered, Matthew at 182 Pendrith Street. Same thing, staff have made multiple attempts via email and phone calls and unable to reach Matthew.
All right, thank you for completing the record, but we're still left with that. So, members, I can recommend, can we have a motion then to defer this application to a later meeting?
I'll make that motion to defer.
Thank you. All right. Seconder, Brad? All right, Mr. Gosh, thank you. And, all right, all in favor on this? Okay. Thank you. We go to our, go to number 20 on our list. Number 20 then is 83 Lynwood Avenue. I'm just going to check on that. Yes, there'll be some urban forestry conditions, it looks like. So the purpose of this application at 83 Lynwood is to legalize and maintain the rear basement addition with walkout stairs that was constructed without the benefit of an authorized building permit. Also to convert the existing ancillary building, a detached garage, into one garden suite by constructing a second-story addition and a two-story side addition. The existing 2 parking spaces with the ancillary building will be maintained. There will be a total of 2 dwellings on this lot. Committee has following materials, copies of minutes from the December 6th public hearing, copy of a survey, site plan, floor plans, a covering letter from Franco Coliallo, and we have a staff report from Urban Forestry. Then we have a number of persons in opposition. I'll just try to name the streets. Persons from Balmoral Avenue, from the South Hill District Homeowners, also Warren Road. Yes, and correspondence in opposition from Jeremy Birch and Eva Young at 207 Balmoral Avenue, and also J.C. Frawley at 82 Lynwood Avenue, as well Glenn Smith from 227 Balmoral Avenue, and a solicitor on behalf of Thomas and Susan Milroy relating to 73, and finally materials in opposition from persons on Balmoral Avenue, again represented by Wood Bull Law Firm. All right. Okay.
Through you, Mr. Chair.
Yeah.
We do have the agent here in person, as well as one speaker, one registered speaker here in person, and another registered speaker in the WebEx meeting.
Yes, all right, so if we could have the agent who's here, that would be great.
Okay, it's already on, right?
Hi, good morning, or good afternoon.
Hi.
We had quite a long, lengthy morning, so I find you have 5 minutes, sir, to tell us about your application and to explain or advocate as to how these matters meet the 4 tests in the Planning Act for minor variance.
Thank you, committee members. My name is Franco Colillo. I'm the agent for the owner present. We are here to present a revised proposal for a rear garden suite and extended basement addition. This was addressing concerns raised by neighbors and from our previous hearing, and incorporating feedback from Urban Forestry from our initial proposal on December 6th. The scope of work remains the same, but adjustments have been made and the garden suite has been reduced in footprint size, gross floor area, and height. Briefly, the project originates from a building permit that was issued in 2022 for a two-story rear addition and new porch, rear porch, including basement walkout, and as well as interior alterations. No work at the time was proposed for the detached garage in the existing rear detached garage at the lot. It was during construction of the rear porch that in lieu of a step footing, that the footing and foundation were extended and in line with the existing basement, and instead of an unexcavated area, the basement area was effectively extended. This, however, affects the zoning bylaw in the sense that the building length and building depth as defined, which are measured to the rear main wall, were affected. Despite this, there was no change to the porch height, length, or width that was previously approved. No changes whatsoever on site. In fact, the only difference is that the basement area of the basement is habitable. Moving to the existing garage, a conversion to a garden suite was a practical choice in order to optimally utilize the existing two-car garage. The existing two-car spaces would be maintained, so a new story would need to be added. And this reuse is similar to numerous coach house conversions in many parts of Toronto, including this area. In fact, on this same street on Lynwood, there is another coach house, a two-story coach house. I list 3 examples of coach houses on it's either this, it's the next one or the one before that, but yeah, that's the one. The conversion of an existing garage is less invasive as opposed to constructing a new building where none existed. The rear garage and driveway already exist and both require upgrading. An exterior, as far as changes from our previous proposal, and to correct the description of work, a side addition is no longer proposed. In lieu of that, an exterior cantilevered stair access to the second floor is proposed, and so we have effectively reduced the footprint of what was previously proposed. There's also, because this is also in a tree protection zone, there is no excavation. As summarized in our arborist report, the extent of the existing garage will remain intact, and the building actually acts as a tree protection zone barrier. So the garden suite will not interfere with the existing canopy. With no side addition proposed, the overall gross floor area of the garden suite has also been reduced, removing one of our previous variances for garden suite area. So previous variance number 6 has been removed, and we had a revised zoning notice done. To summarize for context, the proposal is in keeping with, again, I was referring to gardens, not only other garden suite that were proposed, but coach houses. Keeping with similar recently approved proposals in the area, including 72 Warren Road, 40 Heath Street West, and 627 Lonsdale Road, all approved by committee. 72 Warren Road, as noticed as you've seen on one of the previous panels, is over 7 meters in height. Existing lawfully established two-story converted coach house buildings, I've brought up 3 examples, including one that's, again, on Lynwood Avenue.
All right, I was just to mention that you're coming to the end of the time,
Yeah,
so.
I apologize.
Can you sum up quickly in 30 seconds, say? Yeah.
Okay, there is little to no visual impact from the street. Only the garden suite is visible from the street, and it's located 116 feet from the property line. The basement extension, by moving the rear wall as defined, has triggered variances that this proposal would normally comply with. And again, it is a technical variance with regards to height and angular plane. And again, as far as these setbacks, the side and rear setbacks are lawfully existing and lawfully established, and those will be maintained. Apologies for going over the time frame.
All right, thank you. I noted that there's some suggested urban forestry conditions. Are you aware of those conditions 1 and 2?
Yes.
Those would be acceptable?
We, after we revised the proposal and reduced the footprint, we submitted an application for a permit to injure with urban
Right.
forestry. They are in support of the proposal, and they've given us a list of their requirements in order to issue a permit.
Yeah.
They won't do so until after this
Right.
hearing.
All right, thank you. Yes, members, questions? Yes, Speaker?
So I was a member when this was before us before, and it got deferred. And I do think you've made some good improvements with the stairs being altered so that the GFA is smaller and it's no longer affecting the trees. So I appreciate seeing that. The other concern that there was then, and there remains now, if I sort of look through what the neighborhood concerns are, and I won't speak for my fellow panelists, but it is also a concern for me, is the height, and specifically the additional height that's required to get the parking stacker in there, because that's not really something that we normally consider. It's not something that is sort of part of the whole ethos behind why garden suites are now approved and approvable through some of the city's recent initiatives. And so I guess, so my question would be, would you, if it was the only way to get an approval, consider reducing the height to account for not having the parking stacker, just retaining the 2 existing parking units with the garden suite above, as opposed to going, recognizing that this is what you want, is you want the parking stacker and the garden suite, but if the only way to an approval would be to reduce the height variance, would you consider that?
Well, that's up to the owner. I don't know if you want an answer immediately, but if I could, before he answers, there were 2 factors motivating the fact that we wanted to increase the number of spaces. 2 is, I think property owners, even in this area, should be commended for parking their vehicles indoors. Very few people have a garage, and as you know, most people have multiple cars, and this driveway, to avoid the appearance of having cars parked on the surface, this will help eliminate that. And also there is the security issue of theft, and a car on a car lift is less likely to get stolen. So green space, no reduction, keeping the driveway to a minimum area possible, parking as few cars as possible on the existing driveway, and not increasing the surface parking. So these were all contributing to that aspect. But
That's fair, and you know what, maybe it's unfair for me to ask the question so soon when there are opposing speakers. Maybe
Sure,
your
okay,
client
yeah.
wants to think about what I posed and maybe get back to us before we go into
okay.
committee.
Sure.
Or now, if you know your answer.
Sure. The biggest thing was honestly the theft, because I know it's getting crazy in Toronto, so just protecting one extra car. But if that were to please the committee to take it away, then yeah, of course we would consider it. But I'd appreciate, I know it's just crazy now with Toronto police saying keep your keys by the door and things like that. So it's just another way to protect it, I guess.
And through the chair, sir, for the record, can you just state your name?
Jonathan Corlucci Fusa. And gonna be living here.
Okay, through the chair, we can move on to the registered speakers.
Yes, that's fine.
Thank
Jeff DeJean and Lori Marchildon. Okay, and here and present, okay.
So when I go through, I just want to speak to the slides in my package that have images, 4 or 5, number 4, number 5.
Just what he's there, but.
Sure.
Hi, good afternoon, sir, yeah. Yes, could you give your name and address, please, for the record? And
Yeah, Jeff DeJean from 222 Balmoral.
Okay, yes.
Yeah, so so a lot of the discussion that I think that frames around this is whether this is a permit for a garden suite or whether it's a permit for a 4-car garage, and I'm pleased that that question's already come up. A couple other things to mention, just from the previous presentation. I don't find the examples particularly relevant. They're almost entirely existing structures that are very old. In most cases, they sit on lots that are 200 feet deep and are set well back from the rear property line as well. The ones that have been more recently approved have typically the angular plane rules respected as well. So again, I don't find the very compelling examples. I have a 2-part thesis here, and I'm hopeful that the second half of my presentation is not relevant. I think in the first point that I'd like to make is that the distance between these two buildings is now less than 7.5 meters after the illegal construction of the basement extension, which sits above grade as well. It has a substantial porch structure on it. You can see in this photo here from the second story, this one here, it's a very crowded site. My understanding is that we have these separation rules so things don't get too crowded. And I think it's a kind of natural consequence that the building having been made deeper, now the correct height for that garage structure or garden suite, you can put a garden suite on the main floor as well, would then be 4 meters. And so that's sort of my kind of first and main thesis. In the event that the argument is, sort of relevant, or the committee chooses to allow additional height, I think it's critical that the current height restrictions of 6 meters are adhered to at least, and also the angular plane rules. On the next page here, sorry, these aren't my slides, are they? This is another participant's slides. So, anyways, the next picture is a view from my backyard, which shows a sheer wall that's going to go up right on the property line over 20 feet without the use of the angular planes, and because there's no setback. So it's very, very imposing in terms of the mass of it. There is another image that shows an overhead view. Could we stop the timer just till we get the images? Sorry.
Through the chair, sir, could you provide the date that you provided your presentation or your images?
I submitted it on the around mid-afternoon on Wednesday the 13th, and I did see it in the materials.
Just bear with us for a moment, please. There was a ton of material submitted for this application.
It was marked late as coming in on Thursday morning, but it was submitted before the deadline, if that helps to find it.
Through the chair, sir, the members have seen your presentation materials and your letters because it's in the agenda.
Okay, sure.
Are you
So-
able to continue?
Yeah, I can describe it,
And then
sure,
if
so-
the technology unfreezes by the time you finish, we can just take a quick minute to point out some pictures if that's what you wanted to do.
Yeah.
Okay.
Yeah, so there's a slide in there, number 9, and it shows 3 measurements on it. There's a red line, shows the 5-meter distance between that porch and that garage that protrudes above the ground. There's a 10-meter distance, which is to the back of the actual interior, or the wall of the interior of the house. And there's a blue line there that marks the distance of my house to the back wall, which was 16 meters, and it's incorrectly stated in the applicant's material at 22. So the previous image, which has the title, "The proposed structure is too large," is taken from my back kitchen wall, and that is closer than was represented in the applicant's diagrams. So anyway, so that's kind of my 2.5 minutes on why I think 4 meters is the right height for the structure. There's a sketch in here of a perfectly lovely 1-story garden suite that could be put there at that height, or you could put some cars in there as well if you didn't want to have a garden suite. I do think it's really important, if you look at the scale of this structure here, that angular plane rules and height rules are respected. My neighbor's garage at 73, for example, which respects those angular plane rules, it blends very nicely into the neighborhood landscape, right? And again, the challenge is that when you do put those 2 car stackers in there, that's going to take the top of the first floor up to around 13 feet. And if you respect the angular plane rules, you're trying to cram people into this tiny attic, right? And the solution here is not to have a large flat top structure. The solution is to have at most 2 cars and respect those rules so that for us in the neighborhood, we can then just have, a structure that makes more sense. So, so again, I have a 2-part argument. One is to say it should be 4 meters, and if it's not, it really should respect those other rules. The only other point I'd like to make is that there is a boundary tree here that we share between our properties, which has not been all that well treated, in my opinion. And I would like it if any approval that constitutes an injury to that tree also requires me to provide consent as the other counterparty to the boundary tree. The city has said that's part of the Forestry Act, and so urban forestry is not willing to include that in their approvals, but I was hoping to get that here.
All right. All right. Thank you. Questions, this gentleman? No. None, eh? All right. Okay, thank you, sir. All right.
Okay, through the chair, we can move to the next speaker.
Is that Dennis Wood?
So through the chair, we have Dennis Wood here in person. Oh, online, my apologies.
Dennis, you've been unmuted.
Hello?
Hi, good afternoon, Mr. Wood. Yes. Okay.
Just checking to see whether my system was working on.
Okay, sure.
Before I start, so that we can avoid the problem that beleaguered Mr. DeJohn, I'd appreciate it if staff could pull up the document that's called supplementary submission. I did submit this. That provides a more careful, Appendix A looks more carefully at the zoning provisions, and Appendix B looks at the applicant's examples. But the supplementary submission is the one that will help explain better the concerns. Those are some talking points that I prepared for the committee, but because of the time constraint, let's move to the supplementary document, please. You put it on the screen previously, so it's not in this group. It's in a separate filing that, if you can look, yes, it's called supplementary. No, it's not in this group. It's not in this one. You'll need to find a different document here, marking. It starts with the word supplementary. There we are. Thank you. Perhaps I should sign in now properly. Dennis Wood is my name. I'm a lawyer with the firm of Wood & Bull. Our address is 65 Queen Street West, Suite 1400 in Toronto. We're across the street from City Hall. This is a supplementary submission to my earlier submission, and also is intended to tell Mr. DeJean's story from my client's perspective as a side abutting property. So could we move to the made previously submissions about impacts? Mr. DeJean did start with this illustration, which indicates the extent to which that illegal construction of the basement affects the backyard. And, as I said in my materials, this is not your grandma's veranda. This is a very significant structure, which moves the face of the building out considerably. It'll be, an exterior kitchen or something like that. It's going to be a very important livable space. Could you move to the next? But you can see here that how tight it is. These are the dimensions Mr. John spoke of, 5.1 meters now from the front of that new structure to the face of the building, the east existing garage. The applicant would have you treat this as if there was a 10.2 meter separation. And on that basis, justifies the building seen on the right side. Could we move to the next slide, please? Whoops, there we go. So this is perspective from my client's perspective of the building from the side. And what we are showing you here, and you can tell that both clients, both Mr. Milroy and also Mr. DeJean have gone to a lot of trouble to try to give you a reasonably accurate representation of the effect of that I think that Mr. Goss was asking about, which is if you take the view that it's appropriate to have the garden suite above the garage, then it's appropriate to put angular planes on the roof, and you can have a very effective 49 square meter space, which is all they're going to get in their present proposal. And the only difference is that you get the knee walls where the city intended the knee walls be. Now, let me start with this. The zoning bylaw for garden suites operates very methodically. First test is, what's your face-to-face deference separation? If you're less than 7.5, by definition, the garden suite's 4 meters tall. Once you, if you have a larger distance than that, then at 7.5 meters, you apply at the 4 meter height an angular plane. The applicant has tried to argue, well, if you put that angular plane at 7.5 meters, we don't have any building left. The purpose of this illustration is to show that if you take their existing building and apply a proper angular plane to the front, back, and side, you can achieve reasonable livable space within it and still give them 2 spaces. 4 spaces is a frankly ridiculous request. In my written submissions, I've simply said they can make a choice. You want to have 4 in a stacker, fine, then no garden suite. If you want 2 in a building and a garden suite above, then that's manageable. However, my client's position, as you heard from Mr. DeJean, is they've already soiled their own application by illegally extending the building, and they really should be stuck with a 4 meter high building. Could I look at the next illustrations, please? So this is what it looks like on the side. If you can go to the next illustration. So, I mean, it's apples and oranges in terms of impact on my client's property at 73 Lynwood and from Mr. DeJean's property at the rear. Could I look at the next one, please? So this is an illustration of simply in line drawing showing you what you've just seen. but it just has a little more detail to try to persuade you that this has been very carefully worked out. Can we look at this one, please?
Yeah, Mr. Wood, too, we're at the 5-minute limit, so I'm going to ask you to be quite concise in making final points.
Can you just rip through these slides for me? Go to the next one. This is the one that matters. This gives you the statistics of the 49 and what the effect of the knee wall is. The knee walls are a consequence of anchor planes. I know there are 3 architects on the panel, so that will be self-evident to them. Last point, the three approvals that the committee have given to garden suites previously, none of them had variances for separation. 40 Heath satisfied all requirements except soft landscape. 627 had a height of 5.54 meters with angular planes, support from both neighbors and no objection from the rear neighbor. 72 Warren, as you may know, has a 7-story apartment beside it, a large garage to the rear, and the 7.2 meters is
All
the
right,
effect.
Mr. Wood, we're going to have to just ask you to stop, and then at that point, we're going to get back to the applicant, and he can respond on some of these matters. All right, thank you. Mr. John? Agent, yeah,
Through the chair, we can have the agent come back to the podium, please.
thank you, yes. Thank you, guys, yeah.
There's no question, you just want us to respond to the comments by the
That's right.
opposition?
Yes, that's right. We're
Yeah.
responding to those issues they raised, yeah.
Yeah, with all due respect to the opposition, including the last person, it is certainly, I hope they don't take this the wrong way, but it's not their right to make demands or declaration as to what an applicant or a homeowner can or cannot propose on their property. A garden suite is permitted as of right in every R zone in Toronto. A car lift is also permitted as of right. Again, the position an applicant or another property owner or this lawyer takes to say that we can only have either one, it's simply not a tenable item. The other thing is with regards to the fact that everybody refers to it as illegal construction, there was a building permit that was approved in 2022 for a 2-story addition that included the rear porch with the exact same extents and height as is now constructed. There is no difference. So with all due respect, I think it's unfair to call it illegal construction. And again, with all due respect to the legal counsel, they certainly are not architects, and the proposals that they are even try to show us, well, they're awful proposals that would not work. The efficiency in this case with a flat roof ensures the most amount of usable space. The interior area of the proposed suite is 450 square feet. This is a very, very small bachelor unit. And any kind of knee walls or slope ceiling would not only affect the interior space, but also affect the height. With an accessory structure, height is measured to the highest point. It's never measured to the midpoint. So there is no gain with having a sloped roof. And again, with regards to the angular plane and the technical issue of the fact that from the rear of the existing house, of the new addition, the first and second story, the garden suite is over 10 meters, just over 10 meters. The angular plane, when measured from 7.5 meters, would comply. The proposal would comply if we measured from the rear first and second stories. That variance would not, we wouldn't have that variance. And the 6 meter, we'd be here pleading for a variance of 0.33 meters over the permitted 6 meters. So And again, there is nowhere in the bylaw or with regards to the City of Toronto, the zoning directive, with regards to consideration for existing structures, only a conversion of existing structure. Any addition, which is what we're doing, we're not doing in the new building. The addition, unfortunately, it's their policy to treat it as a brand-new building. And I wanted, again, to emphasize that this is an addition to an existing, lawfully established, lawfully existing structure. And again, when reading the variances, the side and rear setbacks do sound, small, but again, that's, again, I wanted to stress that there are technicalities with regards to the variances which, explain this proposal.
Through the chair, any questions of the members to the agent or comments?
I actually do have more of a comment, which is, I want to phrase it kindly. When you're asked to respond to something, you should be digging up, not down. I think there's nothing wrong with the position taken by the lawyer for the neighbors in saying, here's what I think can fit within zoning. It's not an ultimatum to say you can either build this or that. They were just trying to be helpful in saying what is possible within zoning. But you're absolutely right that you can propose anything you want. That's true. The other point I would make is on the construction of the porch. I recall from the previous hearing that was deferred in this and the materials then, the part that I think is being referred to as illegal construction isn't the porch and the porch structure, because you're right, that was in permit. Right. It was that during construction, it was decided to increase the basement below the foundation for that structure, and that's the part that was out of permit.
Right.
Now, there hasn't been much discussion about that today because your second zoning examiner doesn't seem to have put the same variance for building depth on this variance notice relating to that. So that's why we haven't been discussing it as much, but it still does form part of this application.
Yes.
And that was the issue, was the additional basement piece. So those are my comments, but I don't mean to belittle your
Sure.
your response. It's well taken, but I just wanted that clarification.
Well, I mean, in their prepared letter and in his comments today, I would still say they're overstepping their position by saying what someone should have, or they weren't saying it politely in the sense that this is what is allowed. I'm very familiar with the bylaw, so.
No, that point is well taken. Yeah, no, often this process doesn't lead to people being as polite as they can be.
Well, I don't think anybody was being impolite, but I would certainly never take the position where I can tell an applicant just because I disagree with their variances that their whole proposition is wrong, and that I think with the previous comment in the prepared letter was, well, if he wants to house his in-laws, why can't they sleep in the basement? I mean, this is inappropriate.
No, I agree
Why
that's not material to the committee.
Yeah, why don't we leave that particular issue
We're
and
here
see,
to talk about the variances, so.
are there further questions, other comments or questions from other members? And, all right. Prepared to take this into committee? All right.
So I'll start since I've been
Through the agent, thank you. You can
I'm sorry, yes,
step
thank
down
you,
to the
right.
chair to the
Yeah,
agent,
thanks.
thanks.
Great.
I've been sort of attacking or being asking the most questions on this so far, so I'll start with my comments. I did a bit of math, and if the parking stacker, so the height is 6.33 that they're seeking. If you look on the plans at the original garage was 2.13 tall. And they're now on the revised plans that you can see, or the current plans, page A12, what they're looking at for level 1, so that's the garage including the parking stacker, is 3.73 meters. So if they were to remove the parking stacker, that would be a difference of 1.6 meters, and it would be a height of 4.73 for the whole structure. If you take 1.6 out of what they're asking for right now, which is 6.33, they'd be at 4.73, which would only be a 0.73 meter variance. There still would be the angular planes being encroached on, but much, much less than at 6.33. So I would be inclined to approve the application if they were to, if we left committee and they did agree to remove the parking stacker, as I sort of suggested earlier. So that's what I would throw out to the committee as sort of my position, but maybe we should discuss everything before we go back out of committee.
Yes, Mr. Allison, yeah.
I would disagree, actually. I think the angular planes are critical here. I think you've got side yard setbacks, you've got a setback to the adjacent building, you've got some very sensitive adjacencies to the neighbor at the rear, you've got sensitive adjacencies to the neighbors on the side. For the life of me, I cannot understand why we are still seeing these proposals without angular planes. If you can't meet the angular plane, at least set the plane from the setback that you have. Provide something, right? Like if you're encroaching onto your 7.5 meter setback, right?
Yeah.
And your angular plane is way in the building and you're like, oh, I can't make this work. Well, let's just forget it altogether. I mean, if there was at least, again, and we had this in the earlier session, somebody said, okay, well, we only have, in this case, it's a it's a reduced setback, would it be 6.33? Sorry, that's the height. In this case, a reduced setback.
Yeah, it's only a meter or something.
So
yeah,
I would say it's even more important to put an angular plane in at least from that setback at a height up. And then, the question of fit, I think, would, to the people that spoke in opposition, I think would certainly be a lot more palatable. But to just disregard it altogether and say we can't make it work, therefore I'm just going to remove the variance altogether, I think is, particularly when it's compounded by the fact you've got 7 variances here and you have setback variances on top of that, right? So I think there's 3 variances for angular plane. Just to disregard them altogether, I think just really falls short. And I would agree with the applicant. I think it's a case of, this site frankly can support a 2-car garage with a habitable space above, or it can support what looks like that, but a stacker inside at whatever the permitted height is. But I don't think you can have both, and I don't think it's fair just to I don't think you can have both with the setbacks that they actually have, right? Like it's not even like we're disregarding the angular planes, but they meet all the other requirements. There's some proximity issues to the adjacent neighbors.
So I have a couple counters. But I mean, what I'm suggesting is that they wouldn't have it all. They'd only have the 2 existing parking spots. It would reduce the height a lot. And then they'd have the garden suite above. And some of the counters I would say is the angular planes are designed for any lot. But look at these lots. These are very large lots. And so, like this building, even though it's not like it's closer to the, it's got a reduced setback, so it's closer to the lot lines of this property, it's quite far from the other properties. So the angular planes on the side and the back, the importance of that are a little less. And what I would say is if we impose the angular planes, like the square footage of the garage is only so large. And so I do think there is some truth that you're not going to really get much of a usable garden suite if you do respect all of those angular planes, like the usable space within the floor that you would put above this existing structure is very small, and I do think it's desirable to give an ancillary unit in this neighborhood. So those are my counter arguments.
Sure. Yeah, fair enough. Yeah, I think without the angular plates, the massing is just too imposing. I mean, it really defeats the purpose of what this was really intended to be. There's supposed to be structures in people's, part of the backyard, right? And I know sightlines, they're not a right to neighbors, but when they work, when you look in somebody's backyard, you see a constructed garden suite that's very close to what the sort of intent of what these were supposed to look like. You know, they follow the bylaw. They're not really intended to be two-story boxes back there. And if you, like I said, if you compound that with the setbacks that they have, right, they don't even have the 7.5, and they don't even have the side yard setbacks. So they're asking, it's just too much, in my opinion.
Paul, you had some thoughts?
I'll chime in as well, yeah. So, this thing on every facade, every face, it breaks the rules.
Yeah.
On the side yards,
On the
rear
rear too.
yard, the proximity to the existing building. And then, and I think that and I think what it's not so much, we've seen variances on side yard and rear yard, but those also work to the advantage of the proposed garden suite. It's because then it creates relief for the neighbors. It's not right up against their fence on two sides.
Yeah.
And then it's a blank wall. So,
And there's no laneway in between two buffers.
I think that the building placement and the addition on the back of the main building doesn't allow for the room to put this size of a garden suite in the remaining portion of the lot.
Now, that said, if designed properly, I think this would be a wonderful location for a garden suite and 2 parking spaces. But I just think the way that they've gone about it, and the fact that there's 7 variances for something, it is a very large lot, and it could support
Well,
it.
I would say the
overshoots.
number of variances doesn't really matter so long as each one can be considered minor within the plans, but,
All right, members, perhaps you consider a motion. In Mr. Cheng's absence, I'm not going to vote on this particular matter, so
yeah.
the 3 of you represent quorum and can make a decision.
Yeah, so I'm not going to move anything because there's no point in going out of committee based on what I've heard.
Well, for the reasons that I've outlined, I'll make a motion to refuse the application.
All right, is there a seconder for that motion to refuse application? Yes, there is, from Mr. Gogan. All right, all in favor then to refuse, which is the application. All right, 2 and 1 dissent?
1 dissent.
Yeah, dissent. Okay. Thank you, gentlemen. It's a difficult one. We've now dealt with that, and we'll move on in our agenda.
Hi, Mr. Chair, I am back.
Oh, Mr. Jango.
I was actually back in the early stage of that case, but I don't feel comfortable to suddenly come in and vote.
Well, Mr. Cheng, the chair managed to leave most of his notes in the cafeteria, so we'll do our best with respect to the matters. All right, we'll be moving on then to Dundas, 3124 and 3126 Dundas Street West. And just get that on us here. And that is item 2021. Yes, okay. Thank you. Then this relates to 3124 and 3126 Dundas Street West. Here's the purpose of the application: to convert the existing 2-story, 4-unit mixed-use building into a 6-unit mixed-use building by constructing a rear, 2nd, and 3rd-story addition. So I think it's a rear, 2nd, and 3rd-story additions. Committee has before it plan a survey, site plan, floor plans. We have 1 photograph of the subject property. There's a rental housing demolition and conversion form. And we have email correspondence from transportation engineering. We also have a staff report from the project analyst. Oh, that's simply Metrolinx again with its warning. So, all right. Thank you. And in connection with this item, then we have Joseph Battaglia appears as agent. Madam Deputy Secretary Treasurer, do we have any we have any speakers on this for,
Through the chair, we do have one speaker here in person that wishes to speak.
okay?
And I will also note that it came to our attention, we did receive a late report from Housing, from City Planning Housing Department.
see, yeah.
That's in our very late folders, and staff has that already on the screen. Thank you very much, Jacob. And I understand that this has been sent to the agent as well, but we'll have the agent speak to that.
Okay.
But for the members, the conditions from Housing are also on the screen.
All right, thank you.
Through
Joe?
the chair, so we can start with the agent.
Yes,
Yes, my name is Joe Battaglia,
Yes.
1050 McNichol, Unit 14, Scarborough.
all right, sir, thank you.
I only wish to say that we will adhere to the requests of the Housing, Housing Commission, whatever they are.
All right,
And I really don't have much to say other than I asked for the committee to approve this. The planning comments I looked at, and we are okay with adding those as a condition of approval.
yes, I did,
Right.
yes.
Can I just quickly ask, is there any speakers other than the applicant?
Through the chair, yes, there is. There is a speaker here in person. So we can
Okay, thank you.
move to that speaker
Yeah, thank you.
at this time. Thank you. So we can have the speaker come up, and once you're set at the podium, you can provide your name and address, please.
Good afternoon. My name is Evan Corneal. I live at 3126 Dundas in the rear. This is my partner, Tasha White. She resides there with me. Thank you for your time. I understand this has been a very busy day for you guys, so I appreciate this.
And is your microphone on? Just having a little difficulty hearing you. Yeah.
Is it too far? How's that?
Okay,
That's
that's
all
all right,
right.
thank you. Yeah.
Proximity effect. All right, yeah. So I'd like to start off by stating some reasons I chose to move into this residence in October of 2022. I'm a musician by trade, part-time by trade, hard industry, and I chose this space because it is very isolated. It doesn't share any walls except with the tattoo studio in the front. So it's very advantageous for my professional needs to have a space that doesn't bother other tenants. Units above me, not super ideal. This is a quiet neighborhood, West Toronto, the Junction. I grew up in a small town, so a community-oriented, quiet area, pretty sparse at night. That speaks to me. I intended to grow roots here, spend a lot of time. This is a little bit concerning for those intentions. Building units on top of me also takes away one of the reasons that I chose this residence. There is a skylight in the main living space. This is also the main source of natural light in the unit. If there are any units above me, that is gone. Seasonal affective disorder is something I do deal with, so natural light is super helpful for me. This could lead to a decline in my well-being or any future tenants as well. Since moving in, I have experienced some unfinished renovations, minor things, missing light fixtures, loose baseboards, missing baseboards, things like that, nothing serious. The more serious things come along to the property being poorly maintained. There are leaks that are progressively getting worse, and there was a roach problem that I've done my best. I have correspondence showing my efforts to get property management to deal with these things, and little to no action has been taken on their behalf. In my opinion, repair should be done before anything is added to the property. Also, stating in the tenant rights guideline 6, section 22, a landlord shall not at any time during a tenant's occupancy of a rental unit substantially interfere with the reasonable enjoyment of that unit. To expand on that, it is stated that the landlord is to give any notice to any prospective tenant of a rental unit at the first opportunity to do so before the landlord entered into a new tenancy agreement with that tenant. Considering how quickly things preceding this application begun to happen after my moving in, I suspect that it was already in motion before my tenancy began, and therefore this was never covered. The tenant before me I actually had a chance to connect with before he moved out. His rent was $2,500. That was that was very exciting to me. However, in the negotiation for the lease, that was raised almost a full $1,000 and only stopped at $800 because I agreed to sign on to a 2-year with a 1 add-on. I suspect that rents of my unit, as well as the units being built above me, will be increased far beyond where they are now, and this is only going to contribute to the housing crisis and to the insane cost of living, which, you know, my demographic, I see some people here who are in a similar age group. This is a very scary time to look forward to a continually bleakening future. In the neighborhood, there are already 3 high-rises I've noticed that are being built or have just concluded being built, 2 at the Dundas and DuPont intersection, 1 at Dundas and Pacific. I believe this is going to offer a lot of housing to what is an up-and-coming neighborhood of the Junction, and I believe this will satisfy the amount of people who are needing to come in. These extra 2 units are not necessary for the support of the community, merely to line the property owners' pockets. Furthermore, further west in the laneway by 2 or 3 addresses, there is a 3 or 4 story completely vacant building. I would ask the committee to assess if it's possible to begin using the structures that are already built and are currently being underutilized before adding more construction to the neighborhood. There is already a construction site happening immediately adjacent to my rental property at 3122 Dundas, and this has been very disruptive to somebody who I work from home. Difficult to focus when my house is literally shaking around me. This impacts my sleep, waking up to heavy machinery every morning, 8 or earlier. It's also harmful to the young kids who spend a lot of time playing in that laneway, having large, heavy machinery, idling concrete trucks, you know, producing harmful emissions. It's not beneficial for the community. It's also going to put out the business on the front. I'm sure that they will be disrupted, if not displaced. Little Malta is well established. It's a thriving community. Gentrification of this area is harmful to the people who have been living here and allowing it to flourish up until this point.
All right, sir, thanks. Yes, your minute's up. We don't deal with landlord and tenant matters here, but I hear you on that issue. So thank you, and we'll go back to the applicant for comment.
Thank you.
Through the chair, is there questions from the committee members to the speaker?
I'm sorry, thank you. Yes, Mr. Allison.
And thank you, Mr. Chair. I just had a little bit of concern because there is a bit of a discrepancy with respect to the drawings between the existing and proposed. Perhaps you could just shed a little bit of light with respect to where there are currently windows in your unit, because the existing plan shows 0 windows and a door.
Yeah, this has been a concern of mine as well, especially with the developing property next to us. That's going to move up and cover, so the space itself has 2 bedrooms in the, I guess, northmost part of the unit, right against the laneway, North Dundas, West Clendenin. There's a window in each bedroom, which fire escape, of course, and a smaller window in the bathroom.
Okay.
The bathroom is at the south side of the house, with each bedroom being stacked up, moving north against it. 2 of the windows, the middle bedroom and the bathroom, those are going to be covered by the structure that's happening now. Other than that, it's solely the skylight in the ceiling, and there is a window on the south side of the unit. It's only about 1 by 1 feet, and doesn't allow any light. It doesn't open, so it's not useful for our fire escape. It's essentially non-existent.
So essentially 3 windows, 1 in each bedroom and 1 in the bathroom, and they all are directly on the property line facing what is currently, you said, a laneway.
Those are facing 3122 Dundas. So looking out, you're facing east.
Right. That's correct. Yeah. Okay.
And where's the skylight?
The skylight is in the main space. Having a little bit of trouble. Okay, so the skylight would be above the living family room in the main area, sort of right in the middle of that room.
And its size?
Its size, if I were to estimate, maybe 4 or 5 feet by 3. It's rectangular.
What type of musician are you?
I'm a guitar player, so many things that involve guitar. I try to use the space to support the arts community as best I can, as well, offering recording space or rehearsal space to people that I know.
Thanks.
Thanks.
Thank you.
All right, just getting back to Mr. Battaglia, could you respond to those comments, please?
Well, there's nothing we can do about his skylight, obviously. We want to build a second story, and we can perhaps move him upstairs so he will have a skylight on the top floor. But that will be something that we will be as part of our agreement that we stated at the beginning of this session, that we will comply with the directions of the landlord and tenant people. So we're not trying to kick this guy out. If the skylight is that important to his life, I mean, obviously he might be able to live without it for a little bit of time until we locate him to another unit, perhaps. But that's all we can do. Thanks.
All right, thank you. All right. Members, just any questions to him? No. Okay. Do you wish to take this into committee for discussion? Yes, all right. All right. Mr. Ghosh, yeah.
Yeah, I think it is an appropriate location to add a couple more units in the middle of the junction. I do think that has value. It's not going to solve the housing crisis on its own, certainly not at the rents that it sounds like it'll be charged at, but that is in keeping with the official plan, so then the question is, it is an impact on this existing unit for sure to lose that skylight.
Yes.
There's no doubt about that. But I actually do think the agent's response that this is something they'll have to deal with as part of the housing condition that we would impose if we approved this, gives some solace that at least they'll have to come to some sort of arrangement with the existing tenant in order to develop this property. So I think I find it supportable.
And Mr. Chang, do you want to weigh in on this?
Yeah, I think if we're just looking at the planning issues, it is supportable. Although I feel bad for the guitarist, I hope that, the landlord can come up with a better solution with him, making sure that he can still, it's his career, it's his passion.
Yeah.
So I hope they can find an agreement.
That's a good add-on. I agree. We want to encourage that kind of activity. And all right, prepared to listen to a motion then to motion to approve or refuse approving conditions.
Did you want to add your comments or?
I frankly, it's completely separate, but I had a bit of an issue with the fact that you've got that all of the density is being pushed right up against the rear property line. There's a residential adjacency. If this was residential to residential, we would be all over it. You wouldn't be able to build 3 stories all the way back. And just seeing the angular plane on the drawing there, I think that is where I would have expected a bit of a step back on the 3rd story to avoid a 3-story rear main wall on all of the adjacent properties. That was frankly my concern with the application.
Okay. So no, I appreciate it. I always appreciate your take. Yeah.
You generally, when you mid-rise, for example, you mid-rise, there's the way that from the commercial streets to the residences, there has to be some sort of mitigating.
Yeah,
right?
although the angular plane is being revisited for mid-rises, but.
Well, if it's not necessarily that you need an angular plane, but some form of setback.
Well,
generally, you see a 3rd story.
I do want to mention that typically in Toronto, on a main street like Dundas West, if you have a major development, I think the angular plane starts at 10 meters or 9.5. That's usually the case and that's why you see many condos in downtown have a podium level at that same height and then recess the tower in. So that's usually about 3 stories. And if you have a fire truck that needs to go to the back, then you need a 5 meters height to go in. Well, I don't want to get into too much detail, but I just want to explain to you how the overall urban design guideline or the OP would like to see, and I think it still meets with that general Toronto design guideline. I think it is relatively supportable. Yeah. 7.5 is also a number that sometimes that will be used, but I think luckily this is on the north side of the street, so the shadow will not be casting on Dundas West, but it will be casting back on the lot itself. So sometimes it will be accepted. And I think in this case it is acceptable.
Okay, yeah, I'm satisfied with that. I'm willing to support the application in that sense.
Okay, I'll move to approve the application subject to the, is it housing staff, housing condition?
Through the chair, for the members' consideration, there is also conditions of approval from Metrolinx for this application, not an advisory memo, but they do state actual conditions of approval related to the warning clause in the agreement, purchase and sale agreements, for your consideration as to whether or not you want to impose that condition.
Yeah, I am
My views
very
are the
reluctant to impose it unless Metrolinx
Agreed.
wants to come and have it
I think so,
imposed.
yeah.
So I'll move to approve subject to housing, but not subject to Metrolinx.
All right, is there a seconder for that motion? Mr. Chang? Yes, Mr. Chang, thank you. All right, all in favor then of that? Conditions? All right. The matter is approved. I have your approval, sir. Okay, item 22. The address is 20 Lesley Street. Let's get that. All right, I'm just going to turn to the purpose of what we have on this matter. 22, yes. All right, in connection with the address 20 Lesley Street, the purpose of the application is to permit a personal service shop within the second story northwest corner of the existing 2-story detached building, use within the 2-story detached building. So I take it there's not allowed as a use, but we'll get into that. Committee has the following: plan a survey, site plan, floor plans, 3 photographs of the subject property, a cover letter from the agent. There's also reference to a committee of adjustment decision going back to 2022 affecting the property. There's a private arborist report, and finally there's I see a staff report from TRCA. All right.
Through the chair, we have the agent on the line, as well as there is no registered speakers for this item.
All right, and we'll deal with that. Yes. Okay.
Afternoon. My name is Michael Bissett with Bosefields.
Yes.
Address, I'm here representing the applicant.
Yes, right.
Address is 3 Church Street, Suite 200, Toronto. Just briefly, if you'd like me to just give a brief presentation.
I think we're okay. Yeah. Do we have any questions, or like I've read it thoroughly. I have no objection to approve your case unless you have something to add.
Nope, I have nothing to add if you're comfortable with what you've seen on the record.
Good. So go to committee.
Committee. All right.
Aaron, do you want to do the honors?
Yes, I will propose to approve this application. And there is a TRCA report that is, I believe, a condition that you will need to get the permit. And I believe you will be okay with that. And that's all for the motion.
I'll second.
Thank you.
Fine. All in favor with that condition? Right? Thank you. It is approved. That is 20 Lesley Street.
Through the chair, before we get to item 23,
yes.
again, Mr. Member
right.
Allison has a conflict, so he will be removing himself from the committee room
Yes, thank you,
for the
yes.
hearing of this item and not participating.
All right, thank you. All right, remaining members then, so we're dealing with property at 227 Gerrard Street East. This is item 23. Here's the purpose. To alter the development standards as approved under site-specific zoning bylaws 887 in 2021 and 888 in 2021. Those were approved by the Ontario Land Tribunal for a 7-story mixed use by increasing the number of dwelling units. Committee before has the following communications. It has a survey, site plans, floor plans, and elevations. Has a covering letter from David Morris as agent. There's a private tree report. Then both of those site-specific bylaws are put before us. There's correspondence in support from a Karen Marin and the board, Cabbagetown South Residents Association. So I take it, and Madam Secretary Treasurer, we see no opposition or speaker then, is that right?
Through the chair, that is correct. We just have the agent. There are no registered speakers for this item.
All right. So I'll just get Mr. Morris?
Good afternoon, David Morris here. I'm also with Bousfields Inc. I'm the planning consultant to Cabbage Developments Inc., the owner of 227 Gerrard Street East. My address is 3 Church Street, Suite 200. I'd be happy to give you a short presentation. If
It's kind of like the last case. We have read the information. I am ready to make a proposal to approve it. Do you have anything to add to change my mind, or?
I'm
guess
not
not.
sure that we need a presentation, but I do actually have a couple questions.
Yeah, maybe some questions will be great. Thank you, yeah.
Okay.
So I read your materials, and the thing that I couldn't see anywhere that I just want to know before I consider this is the version of the plans that were approved by the Ontario Land Tribunal. We know that that was 110 units because now you're trying to go up to 124. But what I want to know is how it was reallocated. Has the number of bedrooms increased or decreased? Like what units are changing?
Right, so that's a good question. So we have worked with planning staff to ensure that the unit distribution in the building meets both the intent of the official plan, including the downtown plan, the zoning bylaw, and the growing up guidelines, which stipulates that, which recommends that a minimum of 25% of the overall dwelling units should be larger dwelling units in the range of 2 and 3 bedrooms. And so previously there had been a higher proportion of 3-bedroom units, which are relatively large units that become somewhat unaffordable given their square footage. Through the review of the units on the site and through the sales program, it was determined that they were just too unaffordable to build. And it was decided through consultation with planning staff that a reconfiguration of the dwelling units would be included in the site. So essentially, what we landed on was 44% of the overall number of dwelling units being 2 and 3 bedroom units, but the number of 3-bedroom units was reduced to 7 units.
From?
I have to find that number. I believe it was 11 units, so it was about 10% previously.
Okay, so 11 was reduced to 7 units. And from that, you were able to eke out an additional 14 units? Or was there any other change?
So the individual units were reconfigured. Some were slightly smaller, but we ensured that we still maintained the required indoor amenity space at 2 square meters per unit.
That's good.
But some of the units are slightly smaller to accommodate that change.
Okay, that's what I wanted to know. I'm satisfied.
And I just want to add that based on the submissions and all the reports we are seeing, you're probably at a lot, you've been through the site plan application and you're making such adjustment based on the cost. and the market needs. So I think it's acceptable and supportable.
All right, one of the members like to put forward a motion then on this matter?
Yeah, I mean, I'm disappointed to see fewer 3-bedroom units, but we can't change the market, and planning staff supports it. And I think the fact that even that the density is increased with the overall number of bedrooms increasing is probably a good thing in this location. So, yeah, I agree, it's supportable. So I'll turn that into a motion to approve.
All right, is there a seconder for that motion? That motion? Yes. Yes, all right. Mr. Chang, all right, all in favor, and Jordan is here. That is approved. Got your approval there, thank you very much. And
Thank you.
if someone can ask Jordan to return to the room, we'll move to the next item, 24. We're doing better here, yeah. Okay, just momentarily while it's on our agenda. Item 24, the property address is 174 Windermere Avenue. Here's the purpose: to legalize and maintain a rear second-story addition, altering the existing sloped roof into a flat roof, a front ground floor window projection, and a rear third-story balcony, which are currently under construction without an authorized building permit. Also to permit the partial reconstruction of the existing rear ground floor main wall. The existing one-story ancillary building and detached garage in the rear will be maintained and unaltered. Committee has a plan of survey, site plans, floor plans, 14 photographs of the subject property, 3 photographs of trees on the property, a cover letter from Ashley Leggett as owner, further covering letters from her, a tree removal permit, I see, issued by Urban Forestry. There's an order to apply, of course, relating to the building issue. And commenting agencies, we have simply Urban Forestry replying. There's correspondence in support from persons on Windermere Avenue. There's also opposition from persons also living on Windermere Avenue, and I'm just going to see if there's anything further in that. No, we got it, okay, all right. So that's the background and that's the purpose. Yes, who do we have then for?
Through the chair, we have the agent for this application as well as 2 registered speakers for this application.
All right, just a second here. Dufferin, okay.
Yeah, yes.
Yes, Dufferin.
The applicant can tell us the name and address.
For sure, thanks. Mr. Rubinoff, are you there?
Ian, you've been unmuted. You may turn on your video.
Okay.
Hi there, yeah, can you tell us your name and address for the record, and then we can speak about the application?
Certainly. My name is Ian Leggett. I'm the owner at 174 Windermere Avenue. So thanks very much for hearing our application, my family's application. I appreciate it very much. It's obviously going to be a long evening for you guys, so thank you very much. What we're proposing, the variance maintains the general intent and purpose of the official plan. The squaring of the second floor wall, which most, if not all, of the neighbors' houses have, is in keeping with the general intent of the plan. There's no increase to the gross floor area. It simply takes advantage of the floor space that already exists right now. It creates headspace in the back rooms of the second floor, which is important for us and the functionality of the house. The variance maintains the general intent and purpose of the zoning bylaw. Again, we're not increasing the gross floor area. We're not building further back than the previous structure, and it does not cause privacy or overlook issues that were not already present prior to the renovation. Houses in the neighborhood with deeper or equal setbacks to our property, many with significantly larger square footage. The balcony is an extension of an existing balcony, which is roughly 32 inches by 16 feet, which is also covered by an angular roof. It's just big enough to put a couple chairs there facing one another. The balcony would be functional and not increase the visibility of the neighbors' backyards. If anything, it would take away the vantage point as the roof is no longer sloped. There's pictures of that in CA photos if you want to view them.
And you just have those two variances that you're asking for.
That's correct. Yes. Yeah. So, you know, the one variance being, FSI is 0.35 in our neighborhood. The existing structure as it stands, as you can see, apart from the extension that I did put on already, there's already the size. If I'm not mistaken, the FSI will be the same as it was before moving forward. And then of course the balcony. So there's townhouses running along Budgell Terrace, which backs onto our property, and many of our neighbors' properties that all have third floor balconies that exceed the maximum balcony allowance of 4 meters squared. There are multiple houses on Windermere on our block that have third floor platforms, such as 156 Windermere and 177, both of which have wraparound balconies. I think the variance is desirable for the appropriate development and the use of the land and building. The requested variances significantly contribute to the appropriate development and the use of the land, both proportionate and surrounding properties, and for the functionality in the second floor layout. It will follow will allow functional windows providing light to the rooms and view of our backyard, both of which are fundamental for our enjoyment of our house and our property. Strongly believe that these variances are small in nature. It doesn't increase again the floor space or the setback of the property, and the balcony is an extension of an existing one, which we don't feel increases the ability to view neighboring properties.
Well, I think that's just fine, sir. Panel members, do you wish to go into committee on this?
Just a question.
Okay, a question for you.
Sorry, just
like
keep it
sorry.
brief. Why are we in this order to comply situation? What happened?
Okay, well, I believe you have my permit drawings there. Yeah. I hired an architect we moved into the property October 22. I hired him to do the drawings in October 22. The first rendering, as it states on the drawings, is November 22. I was told that committee would not be something that we were going to have to deal with. I was told that, that was the information I was given. Come June of 2023, when we purchased the house, it was in a state of significant disrepair, completely falling apart, literal holes in the side of the house, things of that nature. When we moved in, the boiler was broken. Purchased the home because we had the ability to get into the neighborhood that we want to be from. I'm originally from here. I'm very fortunate to be able to get back in. It's in the school zone that my kids want to go to, or that I wanted my kids to go to, and they're flourishing. I really was hoping that I would be able to, as the drawings had already started in November of 22, have the drawings a lot sooner than I did. The drawing process was coming along, and to be honest, I figured that if we didn't have to go to committee of adjustments by the time that I got the permits, they would have caught up. I take full responsibility for jumping the gun on that. I'm a big boy. I know that what I did was incorrect. I paid for it in time and money, of course. So in August, my family and I are living in the basement. As you can see, this is my office. As the boiler room. I wanted to get moving because I was hoping to be able to close the property in before winter. August, I believe, 18th, somebody called the city, 311, I guess, and the building inspector showed up and said that I obviously needed permits for this. To August, still don't have permits. Still don't know that I have to go to committee of adjustments, and I stopped.
Okay. So the house is in the photographs that were submitted. That's the current condition of the house.
That's correct. The photos with the Tyvek wrapping the square back there. That's the current state of the house. There are other photos showing the slope back wall. That picture at the top there is a picture of my backyard with the slope wall. And then there are, other photos.
Thanks, sir. Just exceeded the 5 minutes.
Oh,
Yes.
that was my question. So thank you very much for
So-
sharing that. It's appreciated. Again, we were sympathetic with your situation, but again, the building department is your friend. They protect you and your neighbors from things that we can't foresee. So
100%.
Well, hopefully we'll get you on track. Okay.
Yeah. Okay.
All right, thank you. Stand by, and so there are speakers.
Sorry, I just.
Oh, yes, okay.
Oh, there are speakers.
We have several speakers, yes.
Okay, I was just going to ask a quick question to confirm that he's acting as his own contractor. Is that?
Let it go, sure.
If we can.
I remember I was just asking, are you acting as your own contractor, or is there a property manager on this?
I'm operating as my own contractor. I'm not sure if you can hear me. Yes, I am.
Yeah,
Correct.
we can. Thank you.
All right, we'll proceed to the next speaker, and then Madam Deputy Secretary Treasurer, that'd be good.
Ferris Day, you've been unmuted.
Hello, good afternoon.
Oh, hi, sorry, I just had to unmute.
Yeah, thanks.
I'm here with my husband,
All right,
Shahid Sheikh,
yes. Would you give
and
your?
he's been,
Sorry.
oh, sorry,
why-
Fareshta Hashimi and Shahid Sheikh. We live at 176 Windermere Avenue,
Thank
and
you.
our house is the one that's closest to Ian and Ashley's property line.
I see, okay. All right. What would you like to tell committee?
My husband's going to speak on our behalf.
Basically, we have been in this neighborhood for over 15 years. Ian is correct when he says that the house that they purchased was in a state of disarray. The previous owners had neglected it, whether for whatever reason, and it did need major repairs. And so we were quite glad to see that a family had come in who could do this type of repair and had the foresight to do it before the winter started, and things got really bad. There's really, as far as what they're doing to it structurally from our side, that changing the wall elevation, it affects us in a very negligible manner. I would have to be really straining to see that it obstructs my view. In a general day, I wouldn't even notice it once the cladding and that tie back is gone. So as far as we're concerned, it does not affect us whatsoever. And we're the closest ones to him. We share the property line right beside his wall. So as far as we're concerned, we're fine.
Okay, yeah, you're not objecting to either of the variances then? No?
Nope.
Okay. Thank you very much. I think we'll just go on to another speaker. Again, the sir.
Through the chair, are there any questions of that speaker? No? Okay, so we'll move to the next speaker on the list.
Is it Azdek Hashemi and Mark Twist? So we have noted as speakers in opposition, and they appear to be at 172 Windermere Avenue, but.
Mark, you've been
Hello?
unmuted.
Hello, yes.
Hi, it's Azadeh Hashemi and Mark Twist here.
Thank
We've
you.
been living at 172 Windermere Avenue since 2007. Thank you for allowing us to speak. I just wanted to give you a little bit of background about our neighbors, Ian and Ashley. When they first moved in, we were very ecstatic that they're moving in. They're going to fix up the place that was livable next door. The last owner was still living there, so it wasn't a condemned building by any means. And there were family living there that moved out, and they were living upstairs until they started the renovations. I do agree that the renovations were needed, but it wasn't in a state where it couldn't have gone through the permit process. When they first moved in, our kids started playing together. We tried to become friends, but then shortly after, our neighbors without permit cut the trees that were in the back corner on the southwest corner of on their side of the property without permit. Again, trying to be good neighbors, we didn't raise any objections. This was done without permit, and again, it wasn't There's claims that the trees were not in healthy condition, but I can't attest to that, but there was no permit. Last year when they started their construction, given Mr. Leggett's profession as both a real estate agent and a contractor, I do not believe that he wouldn't have known that there is a permit required and that there would be variances when you're changing the building envelope. We assume they have the permit, and then once there was a stop work order, we were told that they've stopped the work. The property, if you look at it, the two supporters, if you look at 176, so we're right to the south. 174 projects out further from our house, so the elevation and the third floor deck, as well as the second floor, the changing of the roof into a vertical, directly looks at in our backyard, into our deck, into our backyard, which we have been enjoying since 2007, and it does intrude on our privacy. Also, the other supporter on Windermere Avenue, it's on the other side of the street and will have absolutely zero impact. The changes requested have zero impact on them. So I just wanted to provide some context in terms of why we're opposing versus the two supporters. And then we don't believe that the lack of permit was a result of lack of knowledge or bad information. Again, given their professions, it was very much known. And we also know that there's 4 criteria for approving variances, which my husband is going to go through in terms of why we think this is not consistent with those requirements for approving variances. Thank you very much.
Hi, Mark Twist from 172 Windermere, just south of the applicant. These requested variances fail to satisfy the 4 tests for minor variances as stipulated by the Planning Act. I'd like to outline my concerns in light of these tests. Number 1, does the variance maintain the general intent and purpose of the official plan? Proposed variances undermine the intent of the official plan, which aims to regulate development in a manner that respects the character and scale of the neighborhood. A significant increase in floor space index and the oversized balcony are not in alignment with the objectives of the official plan. 2, does the variance maintain the general intent and purpose of the zoning bylaw? Variances requested represent a departure from the zoning bylaw, which is designed to ensure compatibility and harmony within the neighborhood. The excessive floor space index and balcony size do not adhere to the intended regulations and standards outlined in the bylaw. According to Chapter 10.20.40.51B, Bylaw 569-2013, the purpose of the regulating balcony size within the official plan framework is to preserve the aesthetic character of the neighborhoods and maintain a sense of privacy for residents. Balconies are important architectural features, and limitations on their size help ensure that they do not dominate or overshadow neighboring properties, contributing to an overall balanced and harmonious built environment. As demonstrated by the images below that we've submitted, there is a significant impact on our privacy as a result of the 3rd floor addition.
So if you look at the images, that's from our backyard and our deck.
That's from our deck.
And if you basically look at the previous.
Backyard, so this is where we enjoy our private pool area.
So,
go ahead.
So you can see that there's clearly a 3rd floor deck will become an observatory into our backyard. We provided the pictures that we had based on the MLS listing from what it looked like previously. And when there's discussion about increase in square footage, you can see that where the roof is, it's really not usable square footage where someone could stand and look into your backyard.
Okay.
So
I add that there's only 5 minutes for each person to speak about, and I understand you have 2 persons speaking together, but do you mind wrapping up, please?
Yes, thanks for those submissions. So you were over the time limit, and we had to move on. Sorry about that, but that's the way it is. All right, so we should get back to Ian as owner applicant, then to respond.
And through the chair, for the record, there's no questions of the last speaker from the members.
No.
Okay.
Great.
Hi, thank you very much. Can you hear me?
Yeah, so, okay. This is, yep.
Yeah, okay. So I did add to this file the tree removal permit. because I had a feeling that that would come up. I did indeed go through the proper courses. I got the permit, and I had a professional arborist come and remove it. The tree in question was indeed, I believe they refer to it as a dangerous tree. It was overhanging our pool as well. You know, he could stick a stick right from about 4 feet in the air down a hole down to the ground. That's why that was removed. And the other tree, the ash close to us, close to the house there, was cleaned up. That's why we went about that, but I absolutely got a permit for that. I actually included that to show you that I do go through the processes as well. In regards to them saying that they don't believe that I didn't think that I need permits. I knew I needed permits, as I've expressed. I honestly didn't believe that it was going to go to committee. That's, you know, you can take that as it is. But you know, as you can see, I did start the permit process in October. I guess November is the first rendering of 2022. Yeah, I guess.
You're asking for a balcony of 11.6 meters squared. I wonder if you can shorten that, rein that in somewhat, because you've heard the concerns about overlook and privacy from those opposing.
I'd be happy to put privacy screening up. I have no issue with that. I expressed that to Mark and Az the day before. You know, the smaller it gets, I mean, to be honest with you, I have no intention of looking down on anybody's property. I'll make those privacy screens as high as they want. You know, I want to utilize it for growing plants, and it'll be adjacent to my home office up there, and I'd like to be able to work out there in summertime, which I would be in a seated position. You know, so I would prefer not to make it smaller and add privacy screening, but you know, I'd like to move things forward. So.
All right, thanks for this. Members, are there questions of the owner here? No? Showing none, okay, all right. All right then, thanks. I think we'll take this matter into committee for discussion.
I'll make a few comments.
Yes.
First of all, I think this applicant has two very good neighbors. They've come to speak, communicate what their issues were, and very good communication. I hope this doesn't ruin their relationship, because I think it was the best intent, just made some wrong decisions, that's all. But I think that I think the privacy screening is a very good idea as proposed. I think that if we can make it, and I think also that, and just to the other speakers, that if this had come to committee in its current form, because I still find both proposed variances minor in nature, I think that they would have stood a very reasonable chance of getting approved. I can't, nothing's for sure in life, but I would have said that the minimum, the small increase in FSI and the permitted platform area, those are relatively common and acceptable minor variances. So with that, I would say that I support this application. I also support the inclusion of privacy screening on the third floor balcony.
Both sides? For certainty, I would say north and south side
The
to a
sides,
height
not the
of
rear, not to the rear.
1.5 meters.
Yeah.
Yeah.
Yeah. And again, hopefully this gets this project on the right track.
And I see an urban forestry condition. I don't know if that's irrelevant now, but.
Yeah, forestry condition too.
So it's condition two, okay, and condition three.
All right, I have a seconder to that motion, please?
Yeah, I'd gladly
Yes,
second.
all right. All in favor then? All right. The motion carries. Thank you. With those.
Maybe this is another one where it's appropriate to put in the minutes for the record. You know, Mr. Leggett's heard it already, but it'll go on the record as well that we don't condone building without a building permit.
Through the chair, yes, we will put that statement in the minutes.
Philip, that's the theme of today, basically.
Definitely, it's been really a surprise that way. All right, that would bring us to item 25, which is great. Move on excuse me, 1966 Dufferin Street. Here's the purpose of the application then. To construct a new two-story ancillary building, a laneway suite with cantilevered second story on the west side, in the rear yard abutting the laneway. The existing ancillary building, a detached garage, will be demolished. The existing detached 2 1/2 story main dwelling on the lot will remain unaltered. So we've got a two-story, essentially laneway suite. Committee has the following: copies of plan of survey, site plans, floor plans, elevations. We have 5 photographs of the subject property, and we have presentation materials from Freya Malas, if I'm pronouncing that right, as agent. There are 3 form letters in support, and I take it, Madam Secretary Treasurer, do you have any other speakers on this?
Through the chair, just to clarify, those 3 form letters in support are signed by owners occupants on Dufferin Street.
Yes, on Dufferin Street, thank you.
3 owners on Dufferin Street, or occupants and owners. And in terms of speakers, we just have the agent. We do not have any registered speakers for this item.
All right, sir, the applicant, if you could come to the fore, I think we can deal with this in an expeditious manner. Yeah.
Good afternoon. It's Glenn Rubidoff, agent for the owner.
Yes, right. All right. Well, very briefly, you just want to tell us about the application. So it's for essentially, I guess, a laneway house to be built, and
Yep.
Okay.
Yeah, they're demolishing the existing detached garage in the back, which is actually closer to the existing house than the proposed laneway suite. So there's actually more land between the house and the proposed building. There's 4 variances before you. The variances are for landscaping, but it's a very minor variance of 73%, where 75% is required. There's the second variance identified is the distance from the building. As I mentioned, the existing garage was about 5 meters to the existing garage to the house. Now it's 6.03 meters, where the requirements is 7.5 for a 2-story unit. There's a angular plane projection. Again, because we're closer than the 7.5 meters.
Right, yes.
The final one is the height, because it's a 2-story within the 7.5 meters, the requirement is 4 meters, but we're requesting a 6.3 meters. There's a new laneway suite immediately next door to this suite. So there's actually a laneway suite just built right next door, with similar variances. So as you can see there, these are 8-foot ceilings inside. They're not excessive in any way. It's just the way in which they designed it. We feel that this meets the 4 tests of the bylaw, and I'll leave it there. I don't need to, if you have any questions, I'm happy to answer.
Members of the panel, any questions for the speaker? No, I'm seeing none. Okay, all right.
I'll just start. I think it's a very appropriate site to have a garden suite, which is, it's on the main Dufferin Road with a laneway at the back, right on the TEC road. There's already a precedent case right next door. There's no opponent.
Right.
I am very happy to support this application. I don't see any conditions.
I don't think it is. All right, we'll treat that as a motion put forward. Is there a seconder for this motion to approve? Yes.
I say I'm happy to second this application.
All right, all in favor then? We have this, yes. Thanks, Mr. Cheng, too, yes. Okay, that matter is approved, sir. You have your approval. Very good. Okay.
Through the chair, just checking in with staff and members. We do have various speakers on the next item. Does anybody need a comfort break at this time? Okay. All right, so let's take a 5-minute or 10-minute What's better?
Well.
5?
And then
Okay,
5?
let's do a 5-minute comfort break, and we will commence with item 26 in 5 minutes. Thank you.
Very good. All right, very good.
Can we send the drawings for that Langley Suite proposal to some of our other? Tell me that.
Okay, well, I'm winging it as best I can. Wow, is my notes are, anyway, they're probably gone. Oh.
2 closets and a dormer to address the stair to get up.
Guys, Jesus Christ. All right. What time is it? 6:20, for Christ's sake. April 11th.
I wish, right? Yeah, we'll have catering shortly. I know, right? That's the benefit of staying late, I wish.
I felt really sick. Oh, wait, gotta turn off my thing.
Yes, that's true. Yes, that's very true.
The only way I afforded my house was the exact same as he did. He bought somewhere that had
All right.
wiring that had major fixer-upper.
Okay, yeah, see, that's an opposition, oh my. Okay, we have,
For part of the reno was dragging. We moved back into the house
have,
and there was like nothing.
All right, we have, this is a,
People have been living in their house for 40 years and so you sometimes still get the odd thing coming on.
now,
I don't bother. I think always in such disrepair. We have in the building.
yeah.
You always have time to apply.
You know what? I like that excuse because I've done all this. You know, I've had the problems of dealing with building inspectors.
Oh yeah, you're an architect too, so.
You know, in my 20s.
construct a new 6-story apartment building with a rear ground floor deck, side south access stairs, front and rear 6-story, Juliet balconies, front and rear 6-story balconies, as well as side, that's the south, and rear basement walkouts. There will be a total of 10 units on the lot. Committee has the following communications: a copy of a plan, site plan, floor plans, and elevations. There's a Committee of Adjustment decision from 2014 that affects the subject property, and there are supporting materials from Jeffrey Booth, who is an architect. In terms of commenting agencies and reports, we have staff reports from tree preservation. We have a report from community planning. We have transportation services have also given a report. Correspondence and opposition. There are numbers, so I'm just going to name the streets. So we have from persons on Dundas Street to the east, from COXWELL Avenue, from Ashland Avenue, again Dundas Street to the east of COXWELL and Ashland, and then also a late submission, but correspondence in opposition from a Lori Clark at 1935 Dundas East, and a Robert Bradley Holmes at 14 Ashland Avenue. All right, so major, but let's just see who we have here.
Through you, Mr. Chair, we have the agent as well as 3 registered speakers online and 1 registered speaker in person.
Thank you very much. Very, very helpful. I believe the agent is Jeffrey Booth. Am I pronouncing that correctly?
Jeffrey, you've been unmuted.
Good afternoon, Jeffrey Moot, Principal Moot Architect, 139 Carlaw Avenue, Toronto, agent acting on behalf of the owners.
Thank you very much. All right, so we just read over
69 COXWELL Avenue is a vacant lot located along a major street. We are proposing to construct a 6-story mid-rise building containing 10. Hello?
Yes, sorry, I just said yes, sorry.
Okay, thank you. Containing 10 purpose-built rental units. We have submitted a slideshow rationale which addresses sort of each of the individual variances in detail. I hope those items were helpful as part of the review process. I'm hoping to now speak at a slightly higher level. The purpose-built rental housing located along major streets supported by public transportation, bike lanes. These are all concepts which are supported by, which describe the foundation of our proposal and that are wholeheartedly supported in the current version of the official plan, Healthy Neighborhoods. Now, what's less clear in the OP currently is the same sort of open arms level of acceptance of our small scale mid-rise apartment typology. Our belief, however, is that the OP does support opportunities for increased height and density, such as ours, along major streets when considered on an individual basis. So Chapter 4 states, lots fronting onto a major street are distinguishable from those located in the interior of the neighborhood due to characteristics such as better access to public transit, adjacency to developments with varying heights, massing, and scale. In those neighborhoods, such factors may be taken into account in the consideration of a more intense form of development. And also just quickly, Chapter 5 states that variances to a zoning bylaw to grant a height and/or density increase for a particular project can be passed that is greater than the zoning bylaw would otherwise permit in return for benefits such as, among others, purpose-built rental housing. Meanwhile, the direct support, I think, for mid-rise buildings and neighborhoods comes from the more recent expanding housing options in neighborhoods major street study, which I believe we are all familiar with. The EHON Major Street Study is in the final stages of approval by council, is underwritten by the chief city planner, and is recommending acceptance of 6-story mid-rise apartment buildings up to 30 units along major streets. Now, the quote from the study, allowing a broader variety of built forms, such as townhouses and small-scale apartment buildings, along major streets is generally consistent with the official plan. Major streets provide opportunities for additional density along the boundaries of these neighborhoods. We believe that our proposal has combined the merits of both the current OP as well as the updated major street study. We did receive a staff report from community planning suggesting refusal of our application. In that, the final sentence of the report states, I quote, "The proposed variances do not fit in with the city's long-term goal or vision and do not respect and reinforce the neighborhood character." On the one hand, I agree that our proposal does indeed stand approximately 2 meters taller than the existing stacked townhouse development, sort of kitty corner to us as an example of prevailing character. However, our overall density and lot coverage is comparable. On the other hand, our proposal aligns itself almost exactly with the EHON Major Street Study, which proves that we do fit the long-term vision of our city, as that is the most up-to-date information that we have to weigh it against. It had been suggested that we wait until the Major Street Study is formally adopted by council prior to seeking approval here today, which we strongly considered, but we struggled to answer this one question: how could a building typology such as ours be deemed not appropriate now, but then the very same building typology would be read as appropriate in 6 or 12 months from now when the amendments are formally adopted? We know it's appropriate now. We know this because the years of research and consultation that have gone into updating these documents. I will finish on this. We are seeking your support today as we transition to prioritizing purpose-built rental programming in mid-rise buildings in our neighborhoods. Having these units online even 10 or 12 months sooner serves to benefit us all. We are talking about providing real rental housing for real members of our community. Thank you very much.
Thank you. Good remarks. Helpful. Yes. All right. Members of the panel, do you have any questions then of Mr. Mood? Yes.
Maybe I'll reserve them for after.
All right.
Through the chair. Okay, we can move to the registered speakers, and we have first the person here in person.
Good.
If you could please come up to the podium, sir. Thank you. Please clearly state your name into the microphone and your address.
Okay. Good evening. I thought I said good afternoon, but it took so long. Yeah.
Yes.
My name is Basil Al-Mukhtar. I'm the owner of 71 COXWELL, the north side of the 69 COXWELL. So my property is attached to the proposed building, and I have so many concerns. I read all the objections from my neighbors, and I really agree with all of them about the garbage and garbage and recycle and the parking. I myself park on the street, and many times I find it very hard for me to find parking. And I get so many parking tickets because I can't find parking. I park on COXWELL. I'm supposed to park on Dundas, but it's already full. And this property is not showing any parking space, even for visitor or emergency, nothing. They only mention something about bikes. I don't know. All the tenants for the 10 units will have bikes, even though I don't think if they have that. The other thing is, how can they access? It's very narrow, to go to the back with their bikes. I have about 2.5 feet, a sidewalk for my building to go to the back. And according to the drawing, it shows less than 1 feet they will have. Okay, how about the fence? There's nothing mentioned about the fence. Okay, building this, to build this, when I have the demolition before from the previous owner, I had so much damage, and I wasn't compensated with that because the next owner who owned this land, he didn't want to pay for it. And I have to pay from my own expense. I got my sidewalk all damaged, and I got some cracked on my side. I have to fix it all on my own expense because the previous owner sold the place, and I can't complain about it and get it. I thought maybe, I asked him, like, if I can have, like, maybe compensate with half the expense, because it's his problem. He said, no, it's not with me, it's with the other previous. And I decided, because even like when I want to have my internet, the cable guy from Bell, he couldn't get me the cable. I mean, because he has to jump, and was danger to go across from the back to connect me to the internet. So it was disaster for me for more than 2 years to access the back of my place. Anyway, I fixed it like on my own expense. Now, when they did the demolition, like they did a lot of vibration. Now when they're going to build a new property, like a new building, and I don't know, like with this like 6th story, what kind of vibration I will get and how long it will take. The other thing, like making it too high, like more than what the city allow, like make it dark in my place, like no access to light, the sunlight. Like this make it another like reason like to like oppose that. Like it's not like it won't be healthy. My place won't be healthy at all because of that. I have like some other concern, but I think this is the major ones I like really like it's coming to my attention about
I just want to remind that we only have 5 minutes per person. I think we should keep counting that time.
Yeah,
Everybody?
I'm trying to watch the time also.
Yes, we're at 3:44 at the moment.
Yeah,
but,
so these are my main concerns, and also like it's for me like the sidewalk for me like is very important. I don't want to share with him like with 0.8 meter, like I think it's less than 1 foot. And I want to have the fence there, because when we do like snow or something, like I don't want to have theirs and I have to do theirs. This is another concern when we have the snow. I have this long way. I have over 100 feet. Okay, I think I addressed before the 5 minutes.
This walkway that you mentioned, and it's totally on your property? It's not like a shared one or a right-of-way over it?
Right now, it's on my property. I have my sidewalk, but he did, like in the plan, I see like there is like just like less than a foot, like wide space, and there's no mention about fence.
Okay, all right.
So that's the
Thank you,
fence
sir.
also takes some space.
And just a quick question,
Sure.
your property, is it 3 apartments, 1 in the basement, 1 on the ground, 1 on the 2nd story, or is it a business in there? What's in your property?
No, just like I have like, okay, so it's, I live on the 2nd floor. I got 2 apartments on the main floor and the basement.
Okay, thanks.
So the other thing, are we talking about residential or commercial? Because this one was residential, the previous one, and now it's turning to commercial. And I got like so many neighbors, they were like telling me, okay, how come we going to have like a high rise like building in our neighborhood? It's going to block the light. Even the ones across the street from my place. People say, have you complained? Have you complained? Because this will block even the light. How about me, who I'm next to it? Okay, I hope, okay, 5:26, okay.
All right, thank you.
Take
Okay.
more of your time.
Thanks very much.
Thank
Okay,
you.
thank you.
Yeah, yes, next speaker?
Okay, through the chair, we can move to the next speaker.
Glenn, you've been unmuted.
Okay, thank you. Glenn Gustafson, 1933 Dundas Street East. My family lives just around the corner from 59 COXWELL. And after reviewing the requested variances, we drafted a letter outlining our concerns. My spouse knocked on doors in the neighborhood one evening and found about 17 others eager to sign the letter with us. And this letter is one of the objections you received. I need to be very clear that the neighbors' opposition isn't a NIMBY reaction to increased density, but rather real alarm at glaring deficiencies. Kitty Corner, and this was referenced by the developer, is a 4-story multi-unit complex that the community fully supported. And next to that, and perhaps more comparable to 69 COXWELL, a single-family home on a small property was recently redeveloped into a 4-story multi-unit rental. And these are very functional builds that have none of the issues that 69 COXWELL will inflict. And the report from city planning also highlights that apartment buildings 4 stories or less are more suitable. Now, some of the neighbors have hypothesized that 69 COXWELL is destined to be an Airbnb hotel, snuck in under the guise of a benevolent developer doing their noble best to address the housing crisis. Clearly, they've come to this conclusion because the building just doesn't function as a residential building. And I recognize that the Committee of Adjustment can't make decisions based on conjecturing its future use. But I want to challenge the developer to prove the neighbors wrong by addressing these concerns by reducing or eliminating the requested variances. And the most prominent concern is the waste generated from 10 units. So our household is extremely waste conscious. We set out about 1 small bin of garbage and a medium bin of recycling every 2 weeks, and about a third of a green bin weekly. So extrapolating from this, we would anticipate the 10-unit building would require at minimum 2 extra large garbage bins, 4 extra large recycling bins, and 4 green bins, amounting to about 55 square feet of waste bins. Stored at the front of the building, they would permanently encroach on a very narrow sidewalk. Stored beside the building, there would be no space in the passageway for anyone to walk through. So this leaves only the backyard as a permanent open-air garbage facility. And even without pillaging raccoons, this would be a horror show in the middle of summer and make the tenant's backyard unusable, as well as impacting the neighbors' enjoyment of their backyards. And this garbage problem will extend onto the street on collection day, with extra large bins taking up much of the sidewalk immediately adjacent to a bus stop. It will be next to impossible for pedestrians, especially in winters, where windrows further reduce the amount of space on the sidewalk. Now, the development does not have any provisions for how residents move around the city. And yes, it's right next to a bus line that goes to a subway station and close to Gerrard and Queen streetcar lines. But it is also next to one of the most widely used bike lanes leading to the downtown. And it's not unreasonable to expect, at minimum, 10 bicycles belonging to permanent residents, but they're given no facility to store or maintain their bikes. They would need to find a way to shoehorn them into their tiny units or squeeze them in amongst all the garbage bins in the backyard. So this development also provides no on-site parking of any type. Even if only half the occupants have vehicles, there's no available on-street parking. As the neighbor mentions, COXWELL has rush hour parking restrictions, and the neighboring streets, Dundas, Battenberg, Ashland, are all at capacity and can't handle more vehicles. Now, I recognize that the variance relates only to visitor and accessible parking, but it does speak to the overarching issue that this building just doesn't work. And related to accessibility, I want to say that I'm flabbergasted that this proposal provides no accessible units. Just entering the building involves using stairs. And so how something with this many units can be permitted with so many barriers to those with mobility challenges is frankly shocking. In closing, I want to reiterate what is in our letter. This development feels entirely disrespectful of people. It is disrespectful of the neighboring residents who will have to live with this building's inability to deal with its garbage, the transportation needs of its tenants, and the additional stormwater runoff that the reduction of soft landscaping will exacerbate. And it's also disrespectful of the future tenants who will be challenged by a building that never contemplated day-to-day needs. We entirely agree with the report from City Planning that these variances are not minor, that it doesn't fit within the physical character of the neighborhood, and that this development should be rejected. The developer needs to reduce the number of units and, as a result, the number and magnitude of these variances in order to mitigate the negative impacts to the neighborhood and ensure good quality of life.
5 minutes is up.
Oh.
Gonna have to.
All right. That was it. Sorry about that.
No. All right, we have a further speaker. Yes, on the line. Paul Grant.
Sorry, I just want to add a general comments to all the speakers that we actually have read all the materials, especially the staff report. And, it's good that if you don't repeat what the other speakers have mentioned, I think we are very well informed, but it's good to hear from your end. So I just hope that everyone can keep it concise and be straight to the point to, if somebody have mentioned something already, you don't have to repeat that. Thank you.
Thank you.
Hello, my name is Paul Grant. Can you all hear me?
We have, and yes, so please go ahead, sir. Yeah.
Yes, I'll be very brief because many of the things have been said already. But I want to thank the committee members for the opportunity to voice my personal opposition to this project as presented. Firstly, I'd like to say,
Through the chair, sorry, sir, can you please state your address for the record?
my name is Paul Grant. My address is 1939 Dundas Street East. And from my backyard, the subject building would be visible from my backyard. So firstly, I'd like to say the size and density of this proposed 6-story, 10-unit building on a single-family size lot does not sit well with the existing neighborhood housing. This proposed oversized building exceeds in height, mass, and appearance of what was once a simple 2-story home prior to being demolished several years ago. The subject building is located 3 houses south of the southeast intersection of Dundas Street East and COXWELL. The backyard of my home on Dundas Street East is only 4 houses east of the proposed building's backyard property line. With a building height of 6 stories, this proposed building would cast a large afternoon shadow over my backyard and garden all summer long. This is a shadowing impact that I strongly object to. My third complaint stems around parking, which has been mentioned already. Currently, we do not have enough permit street parking spots for the car owners in our neighborhood. It is quite common for me to wait in my car an hour or more for a parking spot to become free. Please note that it is common for homeowners residing on COXWELL Avenue to legally permit park on my section of Dundas Street East because COXWELL does not have permit street parking available. This proposed 10-unit project does not have any provision for tenant parking spaces. This will mean there is a potential for 10 more additional cars searching daily for parking spaces on my section of Dundas Street East, which is already short on parking spots for the current residents.
Okay.
So in addition, I am strongly in opposition to the number of units in this proposed building due to the impact it will have on our existing street parking shortage. These are my main issues of objection. Thank you.
Thank you. Any questions for the last speaker? Getting some reversion. See no questions of the speaker, so all right, I think we have one additional speaker left. Okay, staff, can I just, is it Mr. Robert Bradley Coombs?
Through you, Mr. Chair, we have Michael Penner, who will be representing Robert.
Okay, Michael Penner, is it? Yeah, thank you. Well, Mr. Penner? Just unmute him.
Michael, you've been unmuted.
Hi, Michael, are you there?
Through you, Mr. Chair, sorry, I made a mistake.
Oh, okay, that's fine.
It's a different Robert.
Okay.
Okay, Robert Bradley Combs, I cannot locate him. I've sent several emails and tried calling him.
I see. He's not present here physically, all right. Yeah.
Through the chair, and just checking the audience here, and there is no Robert Bradley Combs in the audience in person at this hearing. See none.
Sorry, through the chair. I do see Robert at the moment, but I cannot unmute him. It doesn't appear that he has a microphone or something. Robert, can you hear us? Robert, we're gonna attempt to call you by.
Hello. Hello. This is his wife. Do you hear me?
Yes, go ahead.
Okay. So we don't have anything to add to what was said, so we're gonna skip our turn. Thank you.
Thank you. That does allow us to wrap it. All right, Madam Deputy, I think we're back to Jeffrey Moot as the applicant and owner. So I'd like you to respond, and just a couple of things. Of course, they're saying not a lot of parking being provided for, and parking's a bit of an issue. So perhaps you can just go over what parking arrangements you have, and also accessibility to units.
Of course.
Can use that as a sort of lead off to,
Yeah. Thank you to our neighbors, Glenn, Basil, Paul, and Robert and wife. Thanks for taking the time. The key areas of concern, as I understand, are parking allowance, garbage storage, barrier-free access, and some sun shadowing. Firstly, regarding the parking concerns, the staff report has confirmed that from Transportation Services, it has confirmed that they are satisfied that vehicular parking would not be required on the site. We hope to create a rental building which attracts and supports, TTC riders, bicycle riders alike. Slide 7 in our slideshow, not critical at the moment, but if you could, shows the location of the proposed bicycle parking. Transportation does make note. There's a condition in there that we work with them to add additional bicycle storage spots. And we will absolutely work with them. We would accept that condition, of course. As well, interior bicycle parking spaces provided within the suites themselves. Second point, garbage storage. Proposed garbage storage is exterior only. Slide number 18 shows a diagram for that. We just could not give up a potential rental unit in the basement in order to store garbage internally. We have identified 3 proposed smaller garbage locations, front, side, and rear, approximately 1.5 square meters each. We have found from previous projects that smaller storage areas tied more directly to the individual suites fosters greater responsibility for ensuring a tidy space, if that makes sense, more so than in like an oversized anonymous sort of collection area where people don't necessarily respect the requirements and organizations of recycling, et cetera. The third point about the existence of barrier-free suites, we will absolutely be providing barrier-free suites as per the requirements of the Ontario Building Code and the Accessibility Code. This will be detailed as part of the future building permit submission if we're fortunate enough to reach that stage. And then lastly, there was mention of shadowing to our neighbor to the north. Unfortunately, yes, there will be a reduction in daylight by way of developing the plot of land. It is currently a vacant lot. 3, 4, 5-story building, unfortunately does cause some shadowing to adjacent properties. The majority of the shadowing does happen to the north, along Dundas, and then to the police station, just a bit sort of further to the north there, as we are would be located on the sort of the south side of shadow that would be cast towards Dundas. Happy to answer any further questions.
I just want to start first. Can I ask quickly, are you in a process of site plan application?
Not required, as we're 10 units or less.
Sorry, you're saying, so if there were more residential units, you might also have to get site plan approval. Is that what you're saying? Hello?
Sorry, can you hear me? I was asking.
Yes.
Have you get in touch with the planning staff who prepared a staff report to refuse?
Jeffrey Moot, are you there? You still with us?
Yeah. I think that was it.
Through the chair, we're just trying to get the agent back on the
Sure,
line.
Sure.
Okay.
Jeffrey, are you still there? Through you, Mr. Chair, I see Jeffrey.
Right.
However, I don't see like a headphone icon, so it's possible that he's not connected.
He was very much engaged, so I think that he'd be there, but all right. Yes. Yeah, the question for Mr. Chang was whether, as the applicant, whether he had discussed with the community planner their report and their recommendation that refusal be given to the application. But we haven't had a chance to hear back on that.
Through the chair, staff is making another attempt to try to connect with the agent. It appears the issue might be on the agent's end. Just bear with us a minute.
He's on mute on my thing.
Through the chair, Jeffrey, can you try speaking?
Did he contact us by phone, like just to use a cell phone and speak to us?
Jeffrey, we're gonna attempt to call you. Through you, Mr. Chair, it appears that we're experiencing a connection issue.
I see, okay.
Okay, through the chair and to everyone, it looks like we are experiencing a technical difficulty, so we're going to have to take a quick break while staff try to reboot.
Okay.
So we will do our best to connect as soon as possible. So everyone, please just bear with us. We appreciate your patience.
Okay, take a more water. Yeah, sorry.
Yeah, absolutely.
Hello? It's 14 Grafton is the address.
Okay, so it's item 32. Yeah, so everybody go back on video, make sure your laptops are muted, turn on your microphones. We're gonna do a sound check just to make sure we can hear on YouTube. Sound works on YouTube? Okay.
All right.
So introduce the item. You can take off that not connect to audio.
We'll have to stand down the current item and technically, so people can understand that that's on, right?
Yes, we can mention that. IT is on the way as well, so.
Yeah, let's mention that before we start that. We're standing it down and we'll complete it as soon as.
Which number are we on?
So where
We're
would we
back
start? Sorry.
32?
Through the chair,
Yeah.
so we are having technical difficulties, but we are able to hear item 32 at the moment as we have the agent here in person and no registered speakers for this item. In terms of item 26 that we were in the middle of, we are trying to resolve the issue. We can't continue with that at the moment, but please stand by, hold on. We are trying to still resolve that technical issue. So we're standing down
Hello, can you hear
item
me?
26 to 32 at the moment, and we are going to hear item 32 presently.
And for Mr. Chang, unfortunately, you're going to have to be considered absent for
Yes.
the item that we hear only in the
I think that's
room.
what we have to do, yes.
I'm not sure that he heard me, actually.
I'm going to send Gerrard an email, but you can commence with reading the purpose.
Oh, yes, okay, this is on 32, yes, okay, I get that, yeah. Right, guys. Paper to get through here. 28. Sorry. Getting a little
This is
goofy
14
here.
Grafton.
Okay. 30, 32. All right, members, we'll reassemble, see what we can do here. So 14 Grafton Avenue. The purpose is to alter the existing 1 1/2 story detached dwelling by constructing a complete second-story addition, a modified covered front porch, opening 3 sides of the existing porch, and a new rear basement walkout. Committee has before it these communications, gain a plan of survey, site plan, floor plans, and elevations, 8 photographs of the subject property, a covering letter from Alan Farlinger, agent, and we have, just an advisory from Metrolinx, nothing there. In support, a 5-signature petition in support, signed by owners and occupants of several addresses on Grafton Avenue. So appear to be no opposition to that. All right. Let me just sort of get to that.
Through the chair, we have no registered speakers for this item, and we have the agent here in person.
Congratulations. All right, sir, if you'd be good enough, it's good to tell us about your application and what you're seeking and why you think that it meets the tests that we think about when we think about minor variances.
Okay, hello, committee chair and members. My name's Alan Farlinger, and I am the agent for 14 Grafton. So 14 Grafton basically currently is a 1 1/2 story house. What we want to do is take it out to a 2 full story, and to do that, we need 7 variances, 4 of which are basically for existing conditions. So if you read the list of conditions, the first one is required setback for platform without main walls. That's basically the front porch, which is existing. It's been on the house for 100 years. We want to keep the front porch. It's currently enclosed. and we want to open it up. So basically, right now, it's built at 0.23 meters from the side lot line, and the requirement's 0.45. So that's the first one. The second one is roof slope above the second story. So the owner wanted to do something that's somewhat consistent with the architecture in the area. So we wanted to do a gambrel roof, kind of similar to Dutch colonial style. It's only on the very front 3 feet of the house. From there, the roof is just a simple gable 512 going back. So unfortunately, we had to ask for that variance because the basement, the way that established grades calculated, the basement is considered the first floor. So anything above the second story, this requirement, 5 vertical for 3 horizontal is required. So that's the second one. Now, part of the reason that the basement's considered the first floor is because the established grade is taken from the adjoining 2 properties, one of which has enclosed their front porch. The zoning for the area is a 6-meter setback. That's what our property basically is. The next door neighbor's house is built 6 meter setback, but then when they close the porch, it brings it up further. And then the house to the left, it was just constructed roughly 3 meters from the front. So the lot on the property has a steep decline towards the road. So as we move that established grade calculation, as we move that forward, then it changes the grading and it basically creates a situation where the basement is the first floor. But if you took the grade from the 6 meter, then it's not. Regardless, we're still under the height restrictions, but that's why we need the second variance. The third variance is basically just main pedestrian entrance. So because we've said we're gonna take the front porch off and use the existing front door, now we have to ask for a variance to use the existing front door, and the maximum height allowed is 1.2 meters. We come in at 1.64 meters. Again, it's the door that's been there for 100 years. It's just, again, how established grade is calculated that we're above the, we're above the 1.2 meters. Item 4 is floor space index. We're actually reducing the floor space index on this house from 1.1 to 1.05. There's a poorly built addition at the back that we're just going to totally remove. But needless to say, it's still over the 0.6. If the first floor was, or sorry, if the basement wasn't considered the first floor, we'd be at 0.79. But again, it's still above the 0.6. Side yard setback. This is required 0.45 meters. We want 0.23, which is consistent with the setback on that side of the house, which is a reasonable request. And it only pertains to the front 3 feet that we're building over the porch. The rest is, I guess, grandfathered. So it's fairly minor. And then the roof eave projection, we're already at 0.23 with the setback. And so that's 8 inches. We're gonna need some eave projection just for like a building design standpoint. So, we're looking to go to the lot line with the roof eave projection. And the final one is front yard landscaping. We're coming in at 69%, required 75. Again, because of the slope in the front, there's a lot of retaining walls. And then there's actually an access to a parking spot that's in the basement. So like at 69%, we're at the max of what we could do, and we're only 6% off what's required. So considering the circumstances with the lot and everything, I think it's pretty good that we're coming in at that. So these are the variances we're requesting. I think most of them are in minor. There's examples within this cover letter of similar variances that have been allowed in the neighborhood, and
Okay, so your time's just about up, so please, yep.
and basically that's it. So I think that's the case, and
All right.
welcome questions.
Yeah. Members. Yes, okay. Mr. Allison, please.
Thank you, Mr. Chair. I think this is one of the better applications that we've seen today. I think the presentation was quite thorough in sort of identifying why they're asking for the variances, and I would agree that a lot of the variances are a result of the existing conditions.
Okay.
I like the fact that they've taken an existing building and they've been able to intensify without demolishing it, I think, and do it in a way that is sensitive to its context and the street. It's not often that we see applications that have this sort of degree of sensitivity to the built form. So I think this is a really excellent application, and I'd like to put forward a motion, if it's not too soon, to approve.
It is not too soon.
Without condition.
Yeah.
Without condition, I see no urban forestry condition or anything like that, yes. So I know, there is none.
There's no trees.
Yeah,
Just an
no
advisory report for Metro Leaks.
All right, to be safely ignored, frankly, yes.
I'm happy to second it, and my comment would just be the building being applied for actually fits the context better than the building that's theirs.
Well.
And I think
Good.
you know, we appreciate your patience given our technical difficulties. I think it paid off. I did appreciate your presentation, address the actual variances, which is something that's nice to see.
Yeah.
True. Yes, all in favor then of that motion? I'm putting up here, we're dealing without Mr. Chang at the moment. Yeah.
Right, and through the chair, Mr. Cheng is absent for this item.
Yes, approved.
All right, thank you very much.
Thank you very much.
Thank you.
Enjoy your evening.
Yeah, enjoy your evening, yes, indeed, for sure.
Okay, turn off videos, turn off microphones. We're gonna see if we can fix the.
Okay.
Members, if we can just meet in the hallway for 2 minutes, please.
The room did mute. Like when it started, the room did mute itself. I don't know if that helps diagnose it, but we had to unmute and then kind of lost. Yeah, that would.
Yeah, I would say that's when the issue started.
Yeah. Like around 7. Yeah, it was around 7:20 maybe.
So like 6:37?
Yeah, around 7 or so. Because like that was kind of weird too.
This voice to text is like so temperamental.
It doesn't work.
Puts the word she instead. Should put 90% of that.
you unmuted your laptops to speak and spoke through the computer mic. Who knows?
So you're gonna see his reports now.
Thanks for holding it through.
Scarborough. Yeah.
Community plan. Ah, great.
Thank you.
Actually, who's the new director up there now?
I'm not too sure.
Colin Randall is the audio.
Yeah, he's still a.
See, it could be this block.
Okay. It's got to exist though, because this would be blocking this. This is very this would block all traffic. It blocks this across this corner. And it's connected just fine. And it's using my notebook and this are using the same version. So it's not a version issue. I was using this one for it. It's got to be an issue that's started at 6:30. Which is weird. Usually after I was shooting, I'm reporting the issue to WebEx and our vendor system. But maybe just my whole school, I'm using a cell phone.
Yeah, okay.
But yeah, this, let's say we try to remove that scale from these Canadian pieces.
Okay.
I don't think it's causing it, but.
So you're on, 26? Rebuttal.
Yeah, we should have better. But my notebook I know is working.
Okay, so
That's
let's
why I
bring
know
up
it's
26.
That'd be great if we could. We're
Um,
so close to
Seven
doing it.
Okay, so I think,
27 should be pretty simple.
yeah, so we're gonna have to defer items number 28, items number 29, item 31. Okay? And then what we'll do is old school with the cell phone for those that there's no registered speakers.
The only issue with item 26 to consider is that Aaron was listening to
Yeah.
the
Yeah,
whole thing with multiple opponents and all the rest.
yeah.
Sweet, we have for evaluation.
Cell phone in as well, just for that item, and then say goodbye.
May have to abstain.
So it's not our.
Yeah,
It's
yeah.
not, take it as like.
Yeah.
I'm gonna check on this here, three, but it's probably the same story.
Because,
Oh, they're finished, it's just here?
Before we proceed, we give them the option to defer.
no, we have to automatically.
Well, it's not
have to
ideal,
defer.
but-
No, but he doesn't
It's
agree by
26.
call.
Oh, okay.
We say we have to ask them. Like, because we have to ask them beforehand, because we don't have to.
I have what I need, and I asked like this. I'm here.
Okay, so can we post something on WebEx? Please?
Yeah.
Are we able to do that?
Like just in the chat?
Yeah.
You can share with.
No, no,
Oh,
share
share
what's on the
screen.
screen.
Okay.
So item number 28.
Someone has to present. Yeah. Whoever's presenting.
Well, I know we have this for
Okay, so
registered
just
speaker for item 28, do we have any others? Like any online speakers?
Yeah, there's a lot.
Oh, okay, sorry.
Not your lucky day, sir. I'm sorry.
It's okay.
Are you a proponent or an objector? Just a.
I'm the owner, yeah.
Oh, you're the owner.
Yeah. Wanted to
Have a
experience,
good one.
wanted to experience the efficiency of, well, we were rocking before.
We were.
We
This is shared screen.
Right now?
Right. Yeah, you just want me to.
Yeah, did we spell deferred right?
Yeah, I think so.
Yeah.
2 hours.
2 hours, okay.
Do you want me? There is a Q&A for this hearing, so I just tried to disable it, and I'll put it in there as well.
Say what again?
There's a Q&A.
Oh, okay.
It wasn't disabled this time. Do you want this copy and paste it in there?
No, it's awesome. Okay, okay. Okay, so can we have everyone stand back, please? We need to organize ourselves, it's getting late. Okay, so go back online to YouTube, unmute yourselves, or turn on your microphones, turn on your videos. And we're live on YouTube, sound is good? Okay. Okay, so, Nicole, just read out that. So we're gonna need a motion to defer items. Okay.
So through the chair, we are going to need a motion to defer item 28 for 81 Hazelton Avenue, item 29 for 66 Edgewood Avenue, item 31 for 133 Ronsonsville Avenue, due to technical difficulties.
I'll make that motion.
I second that motion then to defer to a further meeting of Toronto and East York Committee then. That again was for items 28, 29, and 31.
Seconder?
Seconder?
Seconded.
Seconded. Thank you. Jordan? Great. All right, all in favor who are here, and we know that, yeah, that's fine. We know that.
Okay, and it should be noted that these 3 applications have been deferred because of technical difficulties
Yeah.
with WebEx. There are multiple speakers that are registered in opposition, and at this time, we will not be able to hear them this evening. And then we will contact the agents tomorrow morning to set up a new hearing date, okay?
Right, okay.
Okay, so now at this time, we can finish item number 26. We'll get the agent online, and then you guys can deal with those. Okay.
All right.
Exactly, yeah. Or move them on to the next meeting. Yeah.
Let me just.
Don't they have to go through a notification period again,
of the,
though, for the neighbors?
Yeah.
Okay. Okay, very good. All right. This, 26, yeah. Yes, that's Jeffrey Moot as agent, yeah, okay.
So the problem now with this item 26 is the people on WebEx who are in opposition, they're not going to be able to hear his rebuttal. But are they watching on YouTube? That's the problem.
But we could advise.
Can we
them
put a
that
link in the
can
chat?
because we weren't
Can we
going
put a
to
link in the
go
chat?
back to
Yeah.
them anyway, because they,
Okay.
we had the opportunity to ask, so it might be a case of needing to inform them after the fact that.
Okay.
But can't we put a link in the chat to the YouTube and then let them log in?
Yeah, you could. Why don't you send these 3 people an email to sign into, to go into YouTube.
Just put it on the web, put it on the chat.
Or you can put it in the chat.
Put it in the chat, so anyone who wants to log in can go. Send them the link to a whole bunch of like guinea pig videos.
And so Aaron is basically absent now because he's
Yes.
here, but he can't participate. Yeah, so let's just, he can leave.
Turn my mic off.
Why? Okay, can you just let's finish item 26.
Mm-hmm.
I feel like everything should just be deferred at this point. No?
Yeah.
I
On,
think so.
on 26, Aaron, sort of the last comment that got made is Aaron was saying to the applicant, have you discussed discussed with the planner, the community planning report, because it's recommending a refusal and saying that the tests aren't met. So that's, yeah, that's where it got left off. We don't know if he had talked to the planner at all. Yeah. Okay. Just a sec, folks. Yep.
Through the chair to the public, we are announcing now that we are going to defer due to technical difficulties and the number of registered speakers and the inability to contact the agents and have everybody heard at this time. Unfortunately, we will have to defer items number 26 for 69 COXWELL Avenue, with the exception of 32. With item 27, 200 St. Clair Avenue West, item 28 for 81 Hazelton Avenue, item 29 for 66 Edgewood Avenue, item 30 for 14 Holmesdale Road, item 31 for 133 Ronsonsville Avenue, item 33 for 47 Plater Boulevard, item 34 for 93 McKay Avenue, and item 35 for 41 Hook Avenue. We will be in contact with the agents of this application tomorrow morning to reschedule these items to the next available hearing date as soon as possible. Thank you, and again, we apologize for the inconvenience, and thank you very much for today and for your participation.
And thanks staff as well.
And we will also need a motion for that deferral.
Okay, so with our apologies and sincere regrets to those who attempted to attend today and wished to appear, in the applicants, as well as those in interest or in opposition for these matters, I move to defer due to the technical difficulties we've been having. Items number 26, 27, 28, 29, 30, 31, 33, 34, and 35.
I'll second it.
All right, all in favor? All right, the motion carries. Those items are deferred to a future meeting. Thank you, staff and everyone. It's been a trying day, good for us. We got through it.
Thank you. And so with that, we are commencing this hearing at 8:29 p.m. Thank you.